Good morning, everybody. Good morning, everybody. Welcome to the third day of the People's Tribunal on Economic Crime. We will be picking up from where we left off yesterday. Just to give you a brief recap, yesterday we ended off with Mr. Paul Holden, who spoke on the arms deal in South Africa, and that was preceded by Mr. Andrew Feinstein, who gave us a global context of the arms deal in South Africa. That essentially kicked us into the next inquiry, which is that of the arms deal, and that is exactly what we will be continuing with today. So with no further ado, I'd please like to call Mr. Holden to the floor.
Before the evidence starts, I have two things to say on behalf of the panel, if I may. The first is that there was an article in the Huffington Post on Friday which had an interview with Yasmin Sukar, who was described as an adjudicator of the panel. I wanted to clarify, as you can see, that she is not an adjudicator and was not since the panel started on Saturday morning, and one would hope that the Huffington Post or some media will fix that. That's the first thing. The second one is perhaps a little more serious, which is we would like to know, because one thing that is lacking in the submission concerning irrationality is the definition of irrationality upon which you rely. So if somehow irrationality is defined, bearing in mind that what would be irrational is a decision. So I think that, subject to what the evidence leaders have to say, it would be necessary, instead of going on a broad irrationality attack, to identify the decision or decisions on which you rely, which it is said was irrational. And hopefully, if we can work that out before this witness finishes evidence, or Paul can be recalled, I suppose, later, after you have worked this out. But we just, if you're going to go the rationality principle, then we've got to see what is the decision and what is the definition of irrationality on which you rely, and how do you say on the basis of that decision whether it's irrational. Thank you very much. We may proceed.
Thank you, Member Yaqub. Given what you have just said, and also the statement that you made at the end of yesterday in regard to rationality and why it is that this decision was indeed irrational, I think that it might be helpful to address the rationality issue directly before Mr. Holden continues with his evidence.
So a bit more slowly.
It
might be helpful.
Member Yaqub. I believe that it might be helpful, given the fact that the rationality issue has been raised, for us to address it squarely before Mr. Holden continues with his evidence in regard to corruption, which I understand is a different issue to rationality.
Yeah.
Thank you, Member Yaqub. As far as irrationality is concerned, the question of rationality in our law arises under Section 1C of the Constitution. The Constitutional Court has, in a series of leading decisions, held that the principle of legality comprises three requirements. Firstly, that the entity exercising public power must act within the powers conferred upon it. Secondly, that the holder of the power must act in good faith and not misconstrue his or her powers. And importantly, thirdly, that the exercise of public power must not be arbitrary or irrational. When assessing the rationality of a decision, the court is concerned whether there is a rational relationship between the means chosen and the legitimate end that is sought to be achieved. The principle has been formulated by our courts as follows, and I quote, rationality entails that the decision is founded upon reason, in contradistinction to one that is arbitrary, which is different to whether it was reasonably made. The reference there is Minister of Home Affairs v. Scalabrini Center, which is an SCA case. In Democratic Alliance versus President, the Constitutional Court weighed in as follows, and I quote, "The aim of the evaluation of the relationship is not to determine whether some means will achieve the purpose better than others, but only whether the means employed are rationally related to the purpose for which the power was conferred. Once there is a rational relationship, an executive decision of the kind with which we are here concerned is constitutional." So having referred to those two cases, there are therefore, and as far as rationality is concerned, two requirements. Firstly, the end sought to be achieved must be legitimate, and secondly, there must be a rational relationship between the means and the end. It's convenient then for me to begin in this context, in the context of the decision that we're discussing today, with the first requirement. The ends sought to be achieved on the facts before the panel members today is captured in the Defense White Paper and the Defense Review. The affordability report we submit speaks to the means, which we shall address later. At a very high level, one might summarize the content of the two documents, that being the Defense White Paper and the Defense Review, as follows. Both the Defense White Paper and the Defense Review stress that the South African government has a constitutional duty to protect the security of its citizens. Logically, it flows that in order to do so, it must seek to reduce the threats identified as the most pressing. The Defense White Paper, which was approved by Parliament in May of 1996, stressed that South Africa's conception of security would be transformed to stress human security. In this regard, it argued that the greatest threats to human security were socio-economic. The following extracts, if you'll permit me, members, are pertinent to this issue, and I'll be brief. At Chapter 1, Paragraph 6 of the Defense White Paper, it is confirmed that, quote, "The government has prioritized the daunting task of addressing poverty and socio-economic inequalities resulting from the system of apartheid. The Reconstruction and Development Program stands at the pinnacle of national policy and, consequently, defense policy." Chapter 2, paragraphs 5 to 7 say that, quote, "The government of national unity recognizes the greatest threats to the South African people are socio-economic problems like poverty, unemployment, poor education, the lack of housing, and the absence of adequate social services, as well as the high level of crime and violence. Accordingly, one of government's priorities is the Reconstruction and Development Program. The RDP is the principal long-term means of promoting the well-being and security of citizens and thereby the stability of the country. There is consequently a compelling need to reallocate state resources to the RDP. In addition to identifying these threats, the Defense White Paper also acknowledged at paragraph 3 of Chapter 4 that, quote, "South Africa does not now and will not in future have aggressive intentions towards any state. It is not confronted by an immediate conventional military threat, and it does not anticipate external military aggression in the short to medium term." The Defense Review, which I've said is a more substantive document, repeated the same principles, but it confirmed at Chapter 1, paragraph 28, and I'll quote again, that the government has adopted a broad, holistic approach to security, recognizing the various non-military dimensions of security and the distinction between the security of the state and the security of people. The greatest threats to the security of the South African people are socio-economic problems like poverty and unemployment and the high levels of crime and violence. The Defense Review also acknowledged that there is no foreseeable military threat to South Africa in the short to medium term. And furthermore, the Defense Review acknowledged that the force design option, which was eventually expressed in the arms deal, which is the decision, was not, due to budgetary constraints, possible in the short to medium term. And this is very important. It states that it has become apparent that national priorities and budgetary restrictions place constraints on defense expenditure. This means that the achievement of a sustainable force design of the magnitude envisaged in the Defense Review will not be possible in the short to medium term. The approval of a force design by the Parliamentary Defense Committee, Cabinet or Parliament does not constitute blanket approval for all implied capital projects or an immutable contract in terms of the exact numbers and types of equipment. At best, it constitutes approval in principle for the maintenance of the specified capabilities at an approximate level. Broadly speaking then, to summarize what I have just quoted, the end sought to be achieved in the decision that we are discussing was the overall enhancement of South Africa's security. To do so, the government would have had to seek to either materially reduce the threats to this security or, at the very least, to ensure that the threats are not exacerbated. And the greatest threats, as I've already said, were identified as socioeconomic. I do not dispute that this end, as an end, is constitutionally legitimate. That being the case, on the present facts, having considered the first requirement of rationality, the real question, insofar as the irrationality of the arms deal is concerned, is the one that you put, Member Yaqub, to Mr. Holden yesterday, namely whether the second requirement under the Democratic Alliance case, i.e. whether or not the means and the end sought to be achieved enjoy a rational relationship. I submit that the question of whether the relationship between the two is rational should be informed by the facts and circumstances before the decision makers at the time. The means used to achieve the ends described in the Defense Review and the Defense White Paper was the arms deal. The arms deal was predicted in the affordability report to exacerbate those threats identified as the most pressing. It follows then that the means do not relate to the ends. The facts before the decision maker were captured in the affordability report, which was presented to the Cabinet Subcommittee overseeing the arms deal in August 1999, and it should be emphasized that it was a central aim of the affordability report and its associated studies to establish macroeconomic impact on the country. I would further emphasize that the affordability report consisted the sole attempt by government to address this impact. The affordability report and its annexures thus form the primary and arguably only attempt to establish the economic facts of the procurement that took place. The affordability report measured the macroeconomic impact with regard to two primary risks, namely an adverse impact on interest rates and the possibility that offsets would not materialize. In this regard, the affordability report was explicit. It confirmed that even if these risks did not eventuate, the impact of the arms deal was to be negative. And it stated in its executive summary that if the risks do not materialize, the arms expenditure program has limited, though non-negligible, negative impact on the economy. So that means that even on a best case scenario, South Africa's entry into the arms deal would only worsen the country's security as explained in the Defense White Paper and the Defense Review. A doubly concerning outcome in the light of the Defense White Paper and Review's conclusions, being that the socio-economic security was the greatest threat. And the worsening of South Africa's security would of course be antithetical to its enhancement. In the light of the information before the decision makers, I would submit then that such a choice could never be rational. The irrationality, I would add, is compounded by the fact that the government was apprised of the fact that if offsets were not fulfilled, the macroeconomic impact on the economy would be profoundly negative, exacerbating those threats identified in the white paper. Moreover, the affordability report is again explicit in that it states that it is impossible to guarantee that offsets would be fulfilled, and, in fact, that there were material risks that the arms deal contractors had factored in any potential fines for non-compliance into their sales price. Noting in advance that the civilian offsets constituted the vast majority of the offset program, the following paragraph included in the affordability report is, I submit, of primary importance. There is, and I'm quoting, there is mixed empirical evidence internationally regarding the percentage of NIP and DIP contractual commitments, which are typically delivered in respect of arms purchases. In the case of DIP, however, experience both locally and internationally suggests that there is a low risk of non-performance in relation to contractual commitments. In the case of NIPs, the risk of non-performance is significantly higher. On the one hand, it is possible or probable that suppliers have priced into their arms contracts some or all of the penalties payable for non-performance, at least at the original 5% level. It may therefore be in their interests to accept this cost rather than to take on the additional risks and potential costs of NIP projects. What I submit is that this paragraph clearly confirms that the Ministerial Subcommittee on the Arms Deal could not have been certain or even reasonably confident that civilian offsets would be fulfilled. This then finally is compounded when read in conjunction with the affordability report's treatment of the 3 largest NIP programs offered by the arms deal suppliers, all of which were steel mills of various types. These programs formed a significant portion of the NIP promised by the arms deal contractors. The affordability report drafters secured outside experts to assess the viability of these steel mills, and these experts raised material problems with the viability of 2 of the steel mills. On this basis, the affordability report counseled caution in assessing the likelihood that offsets would materialize. Quoting once again, given the significant weight being placed on the 3 NIP steel projects, the views of 2 international steel analysts have been solicited to provide an independent assessment of the viability of the projects and of the risks associated with them. They have pointed to a number of commercial, financing, and other risks which collectively raise significant questions about the viability of at least 2 of the 3 projects. In broad terms, the risks tend to support a cautious view regarding the benefits which may accrue from the NIP projects. So, to summarize then, what we submit is that the ends identified in the Defence White Paper and Defence Review were to protect or enhance the security of South Africa's population. The Defence Review and Defence White Paper established that the greatest threats to South Africa's security were socio-economic. It thus stands to reason that any action, especially where it relates to defence, that would exacerbate these threats would be irrational. The means chosen to protect or improve the security of South Africa's citizens was the arms deal. The affordability report explicitly confirms that the arms deal would reduce this security, as the arms deal would have a limited, though non-negligible negative impact on the economy, and the means thus chosen to achieve the ends were on that basis not rationally related. That is what we would submit, and as far as rationality is concerned,
okay, so there are 3 things. Obviously, you will argue this ultimately, and maybe I should just give you notice so that you know where I am at least going on the thing. So that you can manage it. The first thing is I'd still like to know who took the decision and what was the decision and what was the circumstances in which the decision was taken. If we know that, it's essential to know that before we can work out whether the decision was rational or not. And it will be the aim sought to be achieved by that decision maker, not by the white paper. So you need to look at that. The second thing you need to look at, I think, is I think we are mixing up the corruption with the irrationality. Assume there was no corruption in the deal at all. And I must say, having read the papers, I myself find that assumption very, very difficult to make. But assume there was no corruption at all. Would you have been able to set aside this decision as irrational if it had been absolutely and honestly and properly carried out with the highest degree? And don't answer it now. These are the issues. And the third issue is, can you rely ex post facto on what happened later to go back and use that as an argument to say that decision that time was irrational? So in your final argument, you should bear in mind these 3 things and see where we go.
Thank you, Member Jacob. I shall leave it then for a final argument, but state that we do unequivocally agree with you that certainly conceptually corruption and irrationality are distinct
I raise
concepts.
it now because you have your witness here.
Yes.
And if there are additional facts you want to place on record and so on about who took the decision and when and how, you have an opportunity to do that.
You anticipated my question. I was going to ask for your leave to the extent that it's possible for the witness to address those facts that you've emphasized. Thank you. Then I'll continue with Mr. Holden. We finished yesterday on irrationality oh, beg your pardon, yes.
Should I address the issue that was just raised about who made the decision?
So, yes, if you can. I was, yes, yeah, please. Mr. Holden is going to attempt to address the issue factually to the extent that he can. So let's start there if we can.
So very briefly, I don't want to burden you with the very technocratic detail of the whole process of the arms deal, but essentially the decision was made by Cabinet, and Cabinet made that decision based on the final recommendations that were submitted to Cabinet by the ministerial subcommittee that sat at the apex of the decision-making chain in the arms deal. The Cabinet subcommittee included 4 members, which represented the presidency and the 3 ministries that were relevant to the deal. So the members of the Cabinet subcommittee were Thabo Mbeki representing the presidency, Alec Irwin representing the Ministry of Trade and Industry, Stella Sekgao representing the Minister of Public Works, Alec Irwin representing the Ministry of Finance, and finally Joe Modise, who was representing the Ministry of Defence. I hope that's clear.
Sorry, do you have a date?
Say it again.
Do you have a date?
Oh, the date of the decision. The date of the decision was made, I would argue, on the date that the contracts were signed, and that was the 2nd of December, 1999. Those contracts, I should say, entered into force in...
2nd December 1999?
That's correct.
So that was at a time when the president of this country was already the president? Yeah,
That's correct.
So. Yeah, okay. No, it was already the deputy president, not yet the president.
I think that's correct, yes.
Yeah.
Deputy President, Thabo Mbeki.
Okay, thank you very much. Having addressed rationality in those facts and accepting that we will return to them at the end, we proceed in this second session, and it will be in the third session as well, to address the issue of corruption, which is where you ended off yesterday. What I should point out is that this particular session, there's a reason that there are 2 sessions allocated to corruption, which is that the volume of material to cover is voluminous, so voluminous in fact that we cannot expect to cover all of it even during the 2 sessions. The aspect of corruption will be addressed by 2 separate witnesses, Mr. Holden being the first, but I am going to have to ask Mr. Holden to give you the highlights as opposed to delving down into the detail too much. To the extent that further detail is required, it should be covered in the documents that you receive.
And you can assume that we have very carefully read the open secret submission.
Thank you.
Well, the submission on 1999, whoever made it, I can't remember now. Yeah.
Thank you, Member Yacoub. That being the case, Mr. Holden, may I ask you, in your evidence yesterday, you spoke about how Joe Modise was so supportive of large arms purchases. Can you speak about what role he played in the arms deal, and in particular in the Hawk and Gripen contracts?
Certainly. So he was, I would argue, absolutely essential to the transaction. At the time of the deal, he was the Minister of Defence. I should mention that he left the Ministry of Defence and that position in June 1999. By that time, however, the preferred suppliers had already been selected, and those preferred suppliers were the ones that were eventually contracted with in the 99 arms deal. He was one of the 4 members of the Cabinet subcommittee overseeing the arms deal, so he sat at the apex of the decision-making chain. But he also appeared at various decision-making bodies lower down in the chain of decision-making. One in particular that he served on of importance was the Arms Acquisition Council. The Arms Acquisition Council's job was to evaluate the information presented to it by various bidders and then make recommendations to the Cabinet subcommittee. It passed up its recommendations up to the Cabinet subcommittee, which then made its decisions. I would argue that Modise was probably the most important, or if not the most important, one of the most important people in ensuring that BAE Systems was selected to supply, at the very least, the Hawk trainers. And that's evidenced by 2 things, by the Joint Investigation Report and the Draft Auditor General's Report. Now, I'll give a brief digression, if I may, about the Draft Auditor General's Report. if you cast your mind back to 2001, if you can, there was a considerable amount of controversy around the arms deal, and it was decided that the arms deal, the allegations around it, needed to be investigated. After a very intense political tussle, which included my colleague Andrew Feinstein effectively being forced out of Parliament, it was decided that 3 bodies would investigate the arms deal. That would be the Public Protector, the Auditor General, and at that time what was called the DSO, or the Scorpion, the Directorate of Special Operations. Those bodies compiled their findings into a single report called the Joint Investigation Report, which was published in, if I recall correctly, November 2001. As soon as the report was republished, people questioned its credibility, and it's quite an interesting document to read, because the findings of fact that are made within the document are then often concluded by the overall findings. And this led one very prominent arms deal critic, a man by the name of Dr. Richard Young, who was a losing bidder in the arms deal, to submit a PIA request, a Promotion of Access Information request, to the working notes of the Auditor General and all parties to that joint investigation report. And what he discovered was that effectively the joint investigation report was a modified version of the Auditor General's report at the time. But the draft Auditor General's report was about double the length of the final joint investigation report, and concluded a range of findings and facts that were excluded from the joint investigation report. We now know as well that under the terms of and this speaks to continuity, under the terms of the law that was passed under apartheid, which is the Special Defence Account Act, the Auditor General was required to provide a draft of his findings. The Auditor General at the time was a man by the name of Shaukat Faki, to the Cabinet Subcommittee overseeing the arms deal, and they were allowed to give comment, which I think is frankly unacceptable. That the very people whose conduct was being investigated were allowed to provide comment and direct access to the findings prior to their publication. I'll give you a flavor of how irrational some of these decisions became in the Joint Investigation Report. The final overarching main conclusion, I would argue, in the Joint Investigation Report is that there was no corruption, no impropriety in the deal, and the government's contracting position was not flawed. That simply could not have been the case, because what was disclosed to Richard Young was also the report of the Department of Special Operations, which was the Scorpions, and they reported very clearly that they had initiated a formal investigation into corruption in multiple contracts, and they anticipated those investigations would lead to indictments and convictions, which actually did happen in the Shabir Sheikh, and at least indictment in the case of Jacob Zuma. So we rely in our evidence about Minister Modise, we combine the evidence that in the Joint Investigation Report and the Draft Auditor General's report. We rely on the final Draft Auditor General's report, which was submitted on the 2nd of October, which we date the 2nd of October 2001. I should also mention very briefly that this report was not admitted into evidence by the Sariti Commission of Inquiry, which demanded which stated that as we were not the authors of the report, we could not testify as to whether that was the final draft, which I submit as a rather difficult decision to understand in light of the fact that they secured those same documents from the Auditor General themselves. Returning to Joe Modise, what we know from the Draft Auditor General's report is that on the 30th of April 1998, at a meeting of the Arms Acquisition Council, it was very clear that the Hawk had been placed in a low position in the rankings because of its cost. At the time, the Hawk was roughly double the cost of its nearest competitor, which is the Aeromaki aircraft. At that time, he urged you that the Arms Acquisition Council adopt a visionary approach. This is the quote from the Draft Auditor General's report. He urges that a visionary approach be adopted, and he ordered that a new evaluation take place where costs were excluded, which I would submit raises issues of constitutionality. Shortly thereafter, a man by the name of General Pierre Steyn, who was Secretary of Defense at the time, at a meeting of a body that was slightly below the Arms Acquisition Council, it's called the Arms Acquisition Steering Board. This is in June 1998. Steyn orders that this decision is reversed, and he says we cannot evaluate this massive contract without cost as a criteria. I should add that he eventually resigns as a result of this process because he says that as Secretary of Defense, he had to account for this expenditure and he couldn't do so. The following month, 2 months later, in August 1998, Modise again overrules General Pierre Steyn, and he says, and this is a quote from the Draft Auditor General's report, that the political decision needed must not revolve around operational aspects of the aircraft. We must not prejudge, let the politicians decide. In so doing, he ordered that, again, a new evaluation be undertaken where costs were excluded. We now know that that recommendation, which with costs excluded and a series of manipulations around the offsets program, allowed the Hawk to be presented as the best possible bidder to the Cabinet subcommittee overseeing the arms transaction. So I would argue in that action he was absolutely fundamental in ensuring, in manipulating the process to exclude cost to ensure that BAE could be selected.
Thank you. There have also been allegations that Mr. Modise has been the subject of corruption investigations, especially in relation to a company by the name of Conlog. Can you explain what Conlog was and how Joe Modise was involved?
Certainly. In so doing, I will refer the panel to a document which is attached as Annex CCC to my joint submission with Andrew Feinstein. I understand that was a paper copy made available to the panel? Not yet, but it will be made available shortly. This document is a request for mutual legal assistance that's submitted by the National Prosecuting Authority, an affidavit to, as far as I recall, the Channel Islands. In that document, it sets up very clearly that Minister Modise had, in 1997, taken a share in a company by the name of Conlog. Conlog was a technology company that specialized in the production of prepayment meters, so electricity supply prepayment meters in particular. And I'll quote this extract from the affidavit, which explains the situation. It says, Modise's personal finances and business transactions in which he had been involved before and during the arms acquisition process were investigated. During those investigations, it was established that Modise had acquired a substantial shareholding in a company by the name of Conlog Pty Limited during 1997, as a result whereof he stood to benefit by an amount of approximately 20 million rand. So by getting access to this company, he was due to earn 20 million rand. The importance of this is that, I should also point out, so going a bit further back, that the shareholding of the company is particularly interesting to me. The shareholding of Conlog was essentially split between a series of trusts. That's the Kangela Trust, the Ad Astra Trust, the DGL Trust, the Lataba Trust, and the Sataba Trust. And each of these featured a number of members of government who were central to either conceiving the arms deal or were active in the arms deal's execution. The one trust was owned by a man by the name of Ian Dietlefs, who at the time was the chairman of Denel. Another person who owned shares was Ron Hayward, who was the chairman of Arms Corps and a member of the Council of Defense and the Arms Acquisition Council. And then finally, Minister Modise, who was obviously the Minister of Defense, who owned his shares through the Lataba Trust.
Did Modise's involvement in Conlog then constitute a conflict of interest?
I think that's very clear that it did, and the reason why is quite simple. That in BAE Saab's original bid to secure the contract to supply Hawk and Gripens, they provided a list of projects they were going to use, they were going to implement as part of their offsets program. One of those programs was going to be a partnership that would include Conlog. It was estimated, and I quote again from the affidavit, this joint venture was projected to generate Conlog Pty Limited revenues in excess of $600 million over a 4-year period. I should also add that Modise, the quote here ends, Modise and Hayward served on one or more committees which adjudicated the BAE Saab bid. So clearly by having a share in Conlog, which is going to earn money from a BAE offset, Minister Modise had a material interest in ensuring that BAE Systems was selected as the preferred supplier for the Hawk and the Gripens.
That is your evidence today, but you'll be aware that BAE Systems refuted the allegations that were in the public domain. They claimed that as soon as they found out about the involvement of Modise and Conlog, they removed the project from their offset program. What do you make of the refutation?
Thank you for the question. So the BAE quote that was given by their media representative in 2003 was, Conlog was in the very first list of projects that could have been candidate for offsets programs. When we found out Mr. Modise was a shareholder in Conlog, it came off the list. And it does appear that that was probably true, but it sort of misses the point. What we do know is the Government Communications Information Service in September 1999 made public a document that listed the anticipated offset programs in the transaction. Included in that was a project involving ABBSA, which was a joint venture with Conlog. So by September 1999, it was anticipated at that point that Conlog would receive benefits. I would argue, therefore, that the entire time that Minister Modise was serving as the Minister of Defense, and the entire time he was participating in the arms deal selection process, he knew or anticipated, or expected at least, that BAE Systems would implement this project and he would earn financial benefit from it.
So that then would be the first highlight upon which I'd like your evidence, Joe Modise and Conlog. If we can move to the second highlight, it would then be BAE Systems and the agent system. While the Conlog story is shocking, you believe that this is not the only avenue of corruption in the BAE Saab, Hawk and Gripen contract. They were also investigated by the NPA and investigators overseas. Can you tell us more about the investigations in South Africa and abroad and the so-called Red Diamond system?
Certainly. Before I do so, I'm going to point out that I'm going to be referring the commissioners, the panel to three annexes, which are attached to my joint submission. The first is what we call the SFO affidavit, which is Annex S to the joint submission that I made. The second is Annex V, which is a Department of Justice settlement with BAE Systems. And the third is Annex W to my joint submission, which is the Department of State settlement. Returning to the question, BAE Systems fell under the gaze of the Scorpions. It emerges from roughly 2001. We now know what is public knowledge was that in 2008, the MPA secured search warrants that allowed them to search the properties of a man by the name of Vanach Langwane and another man by the name of John Breedenkamp and their associated businesses. They relied in their affidavit seeking a search warrant, which I should add was granted, and the searches were effected, on a supplementary affidavit that was submitted by the Serious Fraud Office in the United Kingdom. As it turns out, the UK Serious Fraud Office had been investigating BAE Systems for a considerable period of time, and in that they had discovered a huge number of payments that were made in the South African case. What emerges very clearly from the Serious Fraud Office document, which sets out the nature of the investigations and what they discovered, was that British Aerospace decided, or BAE Systems decided, to establish a company by the name of Red Diamond in 1998, which was registered in the British Virgin Islands, which I think we all know is a notorious secrecy jurisdiction. Red Diamond was a covert entity that BAE Systems used to contract with marketing advisors and other consultants, largely to keep those agreements secret. And I quote from, the quote is from Gary Murphy, who was the senior Serious Fraud Office investigator. He, and to quote, said, "I suspect the primary reason behind the inception of Red Diamond was to ensure that corrupt payments could be made and that it would be more difficult for law enforcement agencies to penetrate the system."
Thank you. In total, can I ask you how much was paid by BAE Systems to both overt and covert advisors, and who those advisors were?
Certainly. To quote from the Serious Fraud Office document, UK bank statements obtained from the SFO have revealed that BAE paid over £115 million to advisors in order to assist in securing and maintaining of the Hawk and Gripen contract. Of this £115 million, £103 million was paid to so-called covert advisors, and £12 million were paid to overt advisors. Now, the difference between covert advisors and overt advisors were entities or individuals that BAE Systems publicly acknowledged that they had a relationship with, and covert advisors were ones they did not recognize their relationship with and contracted with largely through the Red Diamond system. There were a number of recipients of these funds, and I'll try to deal with them relatively briefly. One of the largest recipients of this funds was an entity by the name of Casewell Services. This company received £40 million in total. The underlying agreement with Casewell was signed with Red Diamond in 1999. 60% of Casewell Services was owned by John Bredenkamp, and the remaining 40% was divided by his colleagues, Julian Pellissier, Trevor Vilmans, Walter Halewax, and Rick Passaportas. Then again, this speaks to continuity. As I spoke about yesterday, in the evidence of Henny van Vuren, you heard that John Bredenkamp was part of a process where he attempted to sell flamethrowers to the South African Defence Force, if my memory serves me correct, in either 1983 or 1985. He was also, as outlined in Henny van Vuren's evidence, known as a sanctions buster for Rhodesia, and I think it's very pertinent, and I think it's very revealing that a man with such deep and abiding apartheid-era connections emerges in the post-apartheid period such a central advisor in the system. When individuals from BAE were interviewed about the role of Casewell Services, and I'll quote this from the SFO document, it says, when formally questioned by the SFO, McDonald, this is a witness by the name of Alan McDonald, who was an employee of BAE Systems, claimed that Bredenkamp and his team's only contribution towards the selection of BAE as the preferred bidder was to advise the company which key decision makers needed to be identified with a view to financially incentivizing them to make the right decision with regard to the Hawk and Gripen contract. He was told that Bredenkamp's team had boasted that we can get to Chippy Shake. Chippy Shake at the time was the chief of acquisitions who oversaw the entire arms procurement process, and that they had actually been speaking to him about the Hawk. In addition, Bredenkamp's UK operations chief spoke of third world procedures required to win the South African deal, an assumed reference to bribery. The second recipient of funds was an entity named Arstow Commercial Corporation that received £15 million. Its first agreement with BAE Systems was in 1998, which was then replaced in April 1999 with Red Diamond. The same witness, Mr. McDonald, in a document that we received subsequently, stated that Arstow was partly used by BAE to make commission payments to Fana Hlangwane, who had been special advisor to Joe Medise, and I'll deal with him in a lot more detail below, and Stella Sekhau, who was the Minister for Public Enterprises between 1994 and 1999, and Minister of Public Works until sometime in 1999. I should point out that between 5 October 1999 and 30 July 2001, Arstow paid Hlangwane just under £5 million. A third recipient was a company by the name of Huddersfield Enterprises, which received £26 million. This was an entity controlled by Richard Charter. The agreement was signed on the 12th of January 1999 and was varied on the 2nd of December to allow a bonus payment of £4 million. I should point out, as you will probably recognize from what I was talking about earlier, the 2nd of December, the day he receives the bonus, is also the day that the final contracts are signed in the BAE system. It's interesting that he also has an overt consultancy with BAE Systems worth £2 million, raising the questions as to why he needed a covert entity to receive funds and why he registered an entity in an offshore jurisdiction to do so. The final one of note, the second to final one of note was Commercial International Corporation, which received £290,000. I highlight this relatively small payment. It's important because the beneficial owner was Fana Hlangwane, and very importantly, he receives this money via the CIC in 1999, the time the arms deal is being negotiated. And then the final recipient is Fana Hlangwane, who through his companies received 51 million rand and 10 million pounds respectively, in addition to the money he received from CIC.
Can you then break down in a bit more detail how Fana Hlangwane was paid by BAE Systems?
Certainly. On the 9th of September 2003, Fana Hlangwane entered into a consultancy agreement with BAE Systems through Hlangwane Consulting, which is backdated to the 1st of January 2002. Under the terms of this agreement, he receives a retainer of £250,000 per quarter. This was varied to allow for ex gratia payments, which included a payment of $8 million in September 2005, and I quote, this is the reason he was paid, for full and final settlement for all additional work regarding Gripen Tranche 3. In total, Fana Hlangwane was paid £10 million through this route. I should also point out that the Serious Fraud Office, when they submitted their documents, said, and I quote again, BAE has not provided the SFO with any written report to justify the size of those payments. Just to go back a little bit, the quote for full and final settlement for additional work regarding Gripen Tranche 3, to remind the panel, it was decided by the South African government that they would separate the BAE systems purchase into 3 tranches because of affordability concerns. Those decisions were made, the South African government had to make further decisions whether to pursue the second and third tranches. Those decisions were made in 2002 and 2004 respectively. So I think we can very reasonably assume that what is referred to in this is the decision by the South African government in 2004 to pursue tranche 3 of the transaction. Another avenue through which Vanachlanguane received funds was a contract between Vanachlanguane and an entity by the name of SANAP, which stands for South African National Industrial Participation. We now know from disclosures by SARB that SANAP was an entity that was set up originally by SARB to act as a vehicle through which they would meet their offset obligations. It was subsequently taken over by BAE Systems, who took control over that organization. In total, he received 51 million rand through various agreements that started in April 2003 and ran until August 2006. This included a bonus payment of 22.5 million rand, which was a bonus should the South African government not terminate tranche 3 of the contract, and if the South African government confirmed that certain offset targets had been met. I would like to point out that the SFO and certainly the MPA was of the impression that the payments to Vanachlanguane were suspicious, and I quote again from the SFO document: "I believe that the varied ways in which Vanachlanguane has received payments in relation to the Hawk Gripen contract is highly suspicious. BAE operated a covert method of payments through the Red Diamond system. However, it appears that even this system was insufficiently opaque to disguise payments to Vanachlanguane. As such, BAE chose Red Diamond and Aster, which I mentioned earlier, to transfer money to Mr. Vanachlanguane. I suspect that this secretive arrangement was designed to facilitate any or all of the following: A, the onward payment of monies by Vanachlanguane to South African government officials who could influence the decision-making process on the selection of the Hawk and Gripen, and or B, payments to Mr. Vanachlanguane himself for influence brought by him whilst he was special advisor to the Ministry of Defence, and or the onward payment of monies by Mr. Vanachlanguane to South African government officials to ensure the tranching arrangements are honoured." I'll just go back by pointing out that in 1990, I think it was as early as 1997, it's actually 1995, Vanachlanguane was appointed as the special advisor to Joe Modise, and he served in that role until the middle of 1999.
Thank you. In your submission, apart from the SFO affidavit itself, you refer to the fact that Vanachlanguane was subject to money laundering proceedings in Liechtenstein. Can you tell us what those investigations showed and where they went?
Certainly. So the investigation in Liechtenstein was undertaken because the Liechtenstein authorities identified transactions which raised concerns around money laundering. They then contacted South African officials, provided them with files of information regarding the transaction, which they regarded as suspicious. Why that information is relevant is that what was disclosed in those papers was that one of the vehicles through which Mr. Vanachlanguane received funds from the entity Aster was through a company by the name of West Unity. And the importance of that is that West Unity was founded in a secrecy jurisdiction in January 1999. That means that Vanachlanguane was forming a company in a secrecy jurisdiction that would eventually receive money illicitly, I would argue, from BAE Systems at the very time he was special advisor to the Minister of Defence.
Okay. Well, there was also an investigation in the United States. Can you tell us what came of that?
Certainly. Before I answer that question, I realize that I forgot to answer a little part of the question before, which is where those proceedings went, the Liechtenstein proceedings. In the end, the MPA attempted to seek an asset forfeiture declaration to seize the funds to ensure they could not be dispersed. Eventually, the situation was resolved by the direct intervention of Menzi Simelane, who, if I am not mistaken at the time, was the National Director of Public Prosecutions. Menzi Simelane met with the accused in this instance, Vanachlanguane. Vanachlanguane provided him a copy with the consultancy agreement, and Menzi Simelane said, well, because there's a consultancy agreement, this implies that this is a legitimate transaction, and there is no reason to pursue this any further, and he ordered that the asset forfeiture unit investigation be suspended and no longer be continued. I think everybody in the room, and certainly the panel, knows that Menzi Simelane was subsequently removed as the NDPP via a court judgment, which ruled that he was not a fit and proper person to be holding that position as a result of testimony he laid in another matter before Parliament. So to return to the question about the United States, if I may, there was an active investigation into BAE Systems by the US Department of Justice and the US Department of State, which ran parallel to the Serious Fraud Office investigation. Eventually, in 2010, the DOJ settled with BAE Systems, for which BAE Systems paid a fine of $400 million. They did not admit to a count of corruption. They admitted to a series of violations of arms export control regulations about the disclosure of brokers. Nevertheless, I find the statement of offense that's attached to the DOJ settlement, I think, is incredibly revealing, and I quote from this. This is what BAE Systems admitted to in their statement of offense. Beginning in 1993, BAE Systems knowingly and willfully failed to identify commissions paid to third parties for assistance in the solicitation or promotion or otherwise to secure the conclusion of the sale of defense articles. BAE Systems made or caused to be made these false, inaccurate, and incomplete statements to the State Department, both directly and indirectly through third parties. BAE Systems failed to identify the commission payments in order to keep the fact and scope of its external advisors from public disclosure. After May and November 2001, BAE Systems regularly retained what are referred to as marketing advisors to assist in the securing of the sales of defense articles. After May and November 2001, BAE Systems made payments to certain advisors through offshore shell companies, which I submit would be Red Diamond, even though in certain situations there was a high probability that part of the payments would be used in order to ensure BAE Systems was favored in the foreign government decisions regarding the sale of defense articles. BAE Systems made these payments ostensibly for advice through several different routes. A second settlement was reached the following year with the Department of State, where BAE Systems paid a fine of $79 million for substantially the same offense. I submit that you should read the Department of Justice settlement alongside the Department of State settlement for the full disclosure of the facts. The Department of State settlement states very clearly, the Department, this is the Department of State, conducted a further review of the Gripen aircraft transactions and identified a license issued by the Department of Justice in June 2002 to Saab NA. The license authorized the export of $160 million worth of US defense articles to support manufacture of the aircraft. The license was part of a broader transaction involving £1.6 billion worth of Hawk and JAS-39 aircraft for the National Defence Force Air Force, South Africa. Based on the information obtained by the department, respondent or its representatives, Red Diamond, made payments to brokers involved in securing the sale to South Africa. Respondent failed to disclose the disclosed payments as required. I submit that by reading these two documents together, it is very clear what BAE Systems is actually admitting to. First, they're admitting to the creation of a system of covert payments to marketing advisors, which they knew would be used or had a high probability of being used to influence government decisions. One of those contracts in which advisors were paid through the system was the South African deal.
Thank you. Both Fana Hlongwane and BAE Systems were asked to speak to these allegations at the Sariti Commission of Inquiry. Can you describe what they said and how the Commission treated their testimony?
Certainly. First, to deal with BAE Systems emerges from the final Sariti Commission report. We're not called to give evidence. They made a submission at the beginning of the life of the Commission. Their sole appearance before the Commission, their representative advocate appeared on the final day of hearings and simply read BAE's submission into the record, and that advocate was not asked any clarifying questions. BAE's statement denied any of the allegations of impropriety and referred to the Department of Justice settlement, which they say cleared them, but they're entirely silent, of course, on the Department of State settlement, which I think implicates them quite clearly. Fana Hlongwane very publicly appeared before the Commission. He demanded before his proceedings that he not be filmed due to security concerns. That request was eventually dropped after some discussion. His witness statement was a very paltry 12 pages long, in which he only dealt with BAE Systems in 3 paragraphs. And if I may, I'll read these 3 paragraphs. I provide a summary of my company's involvement with BAE as a consultant to assist them with the implementation of the NIP program. On or about 10 September 2003, my company duly concluded the written consultancy agreement with SANAP. The agreement was entered into legally between two private entities. The parties agreed to the commercial terms and conditions, which included the remuneration and quantum thereof. My companies therefore have no duty to justify the terms and conditions which the parties agreed upon. The quantum of remuneration agreed between two private entities can never be a criteria applied by third unrelated parties to determine whether there is anything untoward. In the consultancy agreement, it was correctly recorded that my company was able to assist SANAP to market and implement projects pursuant to South African government's NRP program, promoting exports, local sales and investments in and from the Republic of South Africa. I think what's very clear from the witness statement is that it's silent on a whole range of facts, including the payments that he received from ASTO, which was established by the Serious Fraud Office investigation and the investigation by Liechtenstein authorities. It's entirely silent on the Department of State and Department of Justice settlements, and it's entirely silent on his receipt of funds from CIC in 1999. I'll also point out that his argument that because two companies agree a certain fee, that can never be suspicious, I think is spurious, and if that was believed and followed, there could be no corruption investigations at all into any third party, into any company. He was, after he dealt with this in his witness statement, he was not asked a single question in cross-examination. He was not asked a single question by the commissioners. He was asked one clarifying question by his witness, his evidence leader, asking him to respond generally to the allegations of corruption. And in that, he denied, again, all the allegations and stated that the main reason why people raised concerns was because he was paid so much, but there's nothing untoward in being paid so much, to paraphrase what he was saying.
Thank you. Panel members, at this moment, I need to raise a choice which I should then leave in your hands. What we've covered with Mr. Holden so far is 2 of 4 highlights which I intended for Mr. Holden to address. The first being Joe Modise and Conlog, the second being BAE systems and the agent system. The second 2 highlights overlap with the evidence that will be submitted by Witness X. Witness X is a sensitive witness in that his testimony is urgent and important. However, I don't want to make the evidence too disjointed to follow. So at this stage, the choice that I would like to raise with you is whether the panel members would like to raise questions with Mr. Holden in as far as the first 2 highlights are concerned right now, or whether we may adjourn without those questions, come back to Mr. Holden's evidence and ask questions in regard to that evidence in its entirety, and then in the interstitial period, Witness X will give his evidence, which is evidence of personal knowledge of the allegations of corruption.
So for how long would you want to adjourn?
I think if we may, seeing as Witness X has just recently arrived, if we could have 15 minutes, we would appreciate that.
What is the disadvantage of carrying on until 11:15 and finishing off with the questions, and then having the adjournment that we normally have at tea for half an hour and then doing it? Is that a problem?
There is no, Member Jacob, thanks very much. There is no disadvantage to the proceedings in as far as the panel members of the tribunal may be concerned, but there is a disadvantage in regard to Witness X, and I regret that I cannot be fully forthcoming in regard to the difficulties that Witness X may face should he have to wait. I can only ask that you trust that when he does make his submissions and give his evidence, the panel will realize
sorry, you can stop now. The panel has instructed me to say that you may have your 15 minutes, and if you can make it 10 or 5, we'll appreciate it very much.
Thank you, Member Jacob.
Thank you very much. Okay, I take it we are ready to go on.
Yes, thank you, Member Jacob. Thank you also for the indulgence of allowing us to break early for this witness. If I might, I would introduce the witness briefly before he does so himself. Our witness X is Mr. Ajay Sooklal. Until now, we've kept his identity secret because the evidence that he has to submit to this tribunal arises from his personal knowledge and is very important for the purposes of demonstrating the corruption to which the evidence speaks in this section of this tribunal. That being the case, without further ado, I would turn over to Mr. Sooklal. Mr. Sooklal, thanks very much for being here. What I'd like for you to tell this tribunal first is a little bit about yourself, about why it is that the information that you have to provide would be useful to the tribunal in the context of corruption and the arms deal.
Thank you. My name is Ajay Sooklal. I'm
Microphone?
We're just going to move it closer.
Thank you. My name is Ajay Sooklal, and I'm an attorney and previously practiced in Durban and subsequently relocated to Pretoria. When I relocated to Pretoria, I joined a government department and subsequently went back to private practice. In about 2003, I was approached by Mr. Pierre Moineau, the managing director of two companies that are French subsidiaries. The first company is Tint Holding, Southern Africa Pty Limited, and the second subsidiary is Tint Pty Limited.
Thank you. Is it correct for me to say that you have a close relationship with a number of persons who are involved in the arms deal in the higher echelons of the ANC?
That is correct.
And can you describe for the tribunal briefly your association with Thales and its parent company?
In about September 2003 and in Centurion, I was approached by Mr. Pierre Moineau, and he requested a meeting of me after being introduced to Mr. Moineau by a mutual friend. Subsequently, I had a series of meetings with Mr. Moineau, and he explained that he was endeavoring, one, to pursue marketing activities on behalf of his company with me, and secondly, he also touched upon a subject that arose in August 2003. Now, during August 2003, the then National Director of Public Prosecution, Mr. B. Nguka, had intimated at a press conference that he intended prosecuting one Shabir Sheikh, a director of Tint Pty Limited, as well as to prosecute the entity Tint Pty Limited for bribery and corruption. Mr. Moineau indicated that during the press conference, Mr. Nguka had intimated that inasmuch as they had a prima facie case against the Deputy President of South Africa, at that time, Mr. Jacob Zuma, it was, in Mr. Nguka's words, not winnable. Hence, there was no prosecution foreseen against Mr. Zuma. I then was requested by Mr. Moineau that the South African President at that time, Thabo Mbeki, was going on an official state visit to India, and that I should accompany Mr. Moineau on that trip in order to speak to government personnel that would be on the trip in order to endeavor to find out more about Mr. Nguka's statements. During the trip, and more especially in Mumbai, at a hotel in Mumbai called the Taj Mahal Hotel, I had met up with the then Justice Minister, Mr. Penuel Maduna, who was also on the trip. And he and I fraternized one evening, and in as much as I requested that Mr. Moino sought an audience with Mr. Maduna, Mr. Maduna's immediate reaction is, "I do not want to meet that rogue." Subsequently, Mr. Maduna intimated to me that he was proceeding to France to sign a mutual legal agreement in respect of matters of extradition and the like. I then returned to South Africa, and subsequently Mr. Moino then requested that I accompany him on a trip to Paris, which was a twofold. The first was that President Mbeki at that time was going on an official state visit to France, and secondly, Mr. Moino wanted me to meet his boss. His boss was a gentleman by the name of John Paul Perrier, who was the president of Thales International. Now, Thales International is a subsidiary of the group holding company called Thales SA. Now, SA does not stand for South Africa, but that's an acronym in respect of a French company. During that meeting in Paris...
Sorry, can you tell us the exact date of this meeting?
It was in November 2003. So,
and had the Sheikh prosecution started already?
Not at all. Okay. The Sheikh prosecution only initiated in February 2004 with the serving on the indictment on Mr. Sheikh and Tin Pty Limited and 10 other companies belonging to Mr. Sheikh. Now, Thales SA, as I said, the group holding company, SA stands for Société Anonyme in French. And at the meeting with John Paul Perrier at his headquarters in Paris, Mr. Perrier intimated to me that they were endeavoring to make representations to Mr. Mbeki, and Mr. Perrier intimated to me that he had met Mr. Mbeki on a previous occasion in Paris. Mr. Mbeki had come to the head office of Thales SA in Paris, accompanied by then Deputy Minister Issouf Pahad and the Ambassador of South Africa to Paris at that time, Barbara Masekela. They had a meeting, and so Mr. Perrier had...
Sorry, were you present at this meeting, or is this...
No, this was much earlier. Okay. So Mr. Perrier then outlined the issues that arose out of Mr. Bulelani Nguka's press conference, and more especially the bribery and corruption allegations. And throughout my interactions with Mr. Perrier for over 6 years, he continually says that he doesn't know why the South African prosecution authorities are going against his company when there are many other foreign companies involved in the arms deal, and no one seems to be investigating those other companies. They're only looking at his company, Thales. So I remember at that time my senior counsel, after we had left a meeting subsequently in 2004, my senior counsel intimated that he said that methinks Mr. Perrier don't protest too much. Now, after my discussion with Mr. Perrier, I then moved on to a dinner that was being held by President Chirac of France in honor of President Mbeki's state visit. The dinner was convened at the Élysée Palace in Paris, and...
Sorry, Mr. Sooklal, if I can interrupt you there, just for the benefit of the tribunal and the panel, could you give us a sense of Well, let me put it this way. I understand that the French government and Thales in its various forms, sort of with its subsidiaries and what have you all over the world, are intertwined. Can you explain to us the relationship between the French government and Thales? And then once you've done that, can you just orientate us as to who Perrier is, who Moino is within the context of Thales, and who any other important Thales employees are?
Okay. As I said, Thales SA is a company that previously traded as Thomson CSF in Paris. It was wholly owned state company, and during the early 90s, it was converted to a partially state-owned and Dassault, D-A-S-S-A-U-L-T, Aerospace of France had a private equity share in the same company. Currently speaking, Thales SA is owned 29% by the state of France, and the president of France has an automatic right to appoint the chairman of this group company.
Thank you.
Now, the chairman at that time in 2003 of Thales SA was a gentleman by the name of Mr. Denis Ranque, R-A-N-Q-U-E, and he as chairman of the group holding company, Mr. Perrier reported to him. Mr. Perrier then was the chairman of Thales International. Thereafter, Thales International had a company subsidiary called Thales Africa, Pty Limited.
Sorry, thereafter, about when?
The Thales International then had registered a company in Mauritius called Thales Africa, Pty Limited, and they had an office in Port Louis in Mauritius.
It'll be very useful if you give us some idea, even if not precise dates, when you are talking about, so that we can place things in proper context.
All right. I'm just giving a snapshot of the makeup of Thales.
Anyway, I think having spoken to you, I'm sure that the evidence leader will ensure that you do it at the right time, so don't worry.
Thank you. The Mauritian company then held shareholdings in Tint Holding Southern Africa Pty Limited and Tint Pty Limited. And Tint Pty Limited in turn was a majority shareholder in African Defence Systems, which traded in Midrand. Now, Mr. Perrier has been the chairman of Thales International. As Mr. Moino, Pierre Moino, reported to Mr. Perrier, in as much as Mr. Moino was stationed in South Africa. Mr. Moino's predecessor in South Africa was a gentleman by the name of Mr. Alain Tettard. And Mr. Tettard had for many years worked in Pretoria and was the managing director of Tint Southern Africa Pty Limited as well as Tint Pty Limited. Now, I think it's well known that, and we'll come later to that, about Mr. Tettard's role in bribery and corruption. Now, the other role players, I think I better highlight it now, would be, I've mentioned President Ibeki's name, and then Dr. Penwell Maduna, the then Minister of Justice. The other role players was Mr. Kalema Motlanthe, the then Secretary General of the ANC as of 2003. The Treasurer General of the ANC, Mr. Mendi Mzamang. And then we had subsequently Mr. Jacob Zuma. I think we all know who he is. And the other role players are Mr. Shabir Sheikh and Mr. Sheikh's brother-in-law, which we'll hear later about, is Mr. Yusuf Wahed, and Mr. Sheikh's attorney was one Mr. Reeves Parsi. Now, in as much as that is a snapshot of the main role players in my testimony of today,
Yes. May I ask you for one more role player, please? ADS, African Defense Systems. You mentioned that entity. Is there anything else about that entity, whether it be shareholders or directors, that you can explain for us that is relevant to your testimony?
African Defense Systems, it was 80% shareholding was held by TIN Pty Limited, and 20% was held by Futuristic Business Systems Pty Limited, and the chairman of that entity at that time in 2003 was retired General Lambert Molloy.
Thank you. Then where you were in your testimony before I interrupted you was you were speaking about the French president of the time, Mr. Chirac, and we now know, based on the snapshot that you've given us, that the French president had certain powers in relation to appointments that took place at Thales, thus had an interest. Would you agree?
That is correct.
Okay.
In my discussions in Paris, at the morning of my first day in Paris in November 2003, having met Mr. Perrier intimated that only certain people are invited to state dinners at the Elysee Palace, and that evening I would be in the company of Mr. Denny Rank, the chairman of Thales SA. And he said that Mr. Rank would speak to me then.
Mr.?
Rank, R-A-N-Q-U.
Yeah.
Now, Mr. Denny Rank was, as I said, Mr. Perrier's boss. So that evening at the Elysee Palace, I had met up with Mr. Rank, and he intimated to me that I should assist his company in its endeavors to try to quash any looming indictment against TIN Pty Limited. The dinner took place, and subsequently, the following evening, Mr. Perrier called me and intimated that he was going to join me for dinner at the residence of the South African ambassador to Paris at that time, who was holding a dinner in honor of the birthday of the First Lady of South Africa, Mrs. Mbeki. So, having repaired myself to the residence of the ambassador and attending the birthday celebrations, I noticed Mr. Perrier conversing with President Mbeki at the function. Later in the evening, Mr. Perrier came over and intimated to me that the previous night at the Elysee Palace, President Chirac had intimated to President Mbeki that they should bring forces to bear to try to quash any indictment that may arise out of the prosecution of Shabir Sheikh and others. Subsequently, I learned both from Mr. Perrier and Mr. Moino, either in Paris or in Pretoria, that Mr. Mbeki had tasked a three-person panel consisting of Justice Minister Penuel Maduna, the Secretary General of the ANC, Kalema Motlanthe, and the Secretary General of the ANC, Mendy Mzimang, to intervene in the looming prosecution against TIN Pty Limited.
And those charges were then subsequently withdrawn, weren't they?
That is correct. In February 2004, an indictment was served, as I said, charging Mr. Sheikh and his 11 corporate entities, including TIN Pty Limited. Subsequently, during April 2004, I was requested to set up a meeting with Mr. Maduna at his residence. Mr. Maduna agreed to the meeting, and the meeting commenced at 5 p.m. in April 2004 at the Maduna residence. At the meeting was Dr. Maduna, as well as it was attended by Mr. Bululani Nguka, at that time the NPA head. And on the other side, the TIN Pty Limited was represented by Mr. Moino, Mr. Dryman, who was the attorney for TIN Pty Limited, and then the group legal counsel from Paris for Thales's essay, Ms. Christine Gouria. And Ms. Gouria has played an instrumental role in the matters since that April 2004 meeting. Now, discussions flowed from that meeting at the Maduna residence, which resulted in an agreement being reached where Mr. Nguka said that if Mr. Alain Tetard would admit by affidavit that he was the author of a so-called encrypted fax, then Mr. Nguka would see it fit to withdraw charges against 10 Pty Limited in the Shabir Sheikh trial that was set down from the 10th of October 2004. After much discussions in Pretoria and in Paris, and having enlisted support of senior counsel H.K. Naidu SC, we met with Mr. Tetard in Paris, and after much persuasion, he put up an affidavit to say that he was the author of the encrypted fax.
Sorry, Mr. Sooklal, can you tell us about the contents of the fax?
All right.
And go slowly so that we can write it down.
Now, there is a handwritten copy of the encrypted fax that Mr. Tetard, as I said, alluded to say that he was the author. But the typed copy goes as follows. The heading is Thomson CSF Holding, THOMSON-CSF Holding, in brackets, Southern Africa, Pty Limited. And there's a telephone number and fax number of the office in Pretoria. And the fax continues as follows. It's from Alain Tetard, T-H-E-T-A-R-D, date 17th March 2000. It's addressed to Jan de Jamaron. I'll spell that. It's Y-A-N-N, separately D-E, and then Jamaron is spelled as J-O-M-A-R-O-N. The gentleman Jan de Jamaron was managing director of Thales Africa based in Mauritius, and Mr. Jamaron was stationed in Port Louis. The subject matter says, it says subject JZ/S Sheikh. And the letter commences as follows. Dear Jan, following our interview held on 30th September 1999 with S. Sheikh in Durban and my conversation held on 10th November 1999 with Mr. J.P. Perrier in Paris, I have been able, in brackets, open brackets, at last, close brackets, to meet JZ in Durban on the 11th of this month during a private interview in the presence of SS. SS is Shabir Sheikh. I had asked SS to obtain from JZ a clear confirmation or at least an encoded declaration, open brackets, in a code defined by me, close brackets, in order to validate the request by SS at the end of September 1999. This was done by JZ, in brackets, in an encoded form, close brackets. May I remind you that the two main objectives of the effort, and the word effort is in inverted commas, requested of Thomson CSF are, bullet point 1, Thomson CSF protection, during the current investigations, open brackets, Citron, S-I-T-R-O-N, close brackets. And second bullet point, JZ's permanent support for the future projects. Amount 500,000 Rand per annum, open brackets, until the first payment of the dividend by African Defence Systems, close brackets. Yours, Alain Tetard.
You can then proceed, if you will, in regard to the Nguka goings-on.
So it was agreed with Mr. Nguka that the following day, the TINT representatives would repair themselves, accompanied by senior counsel, to the offices of Mr. Nguka at the headquarters of the NPA. The NPA is the National Prosecuting Authority of South Africa. So on the following day, it was decided that the attorney for TINT, Mr. Dryman, accompanied by Ms. Christine Guria, the Group Legal Counsel for Thales SA, would go and inspect the encrypted facts, both the original as well as the type copy that I have just read. This all occurred at the premises of the NPA, and upon the return of the two persons I mentioned, after viewing the encrypted facts in the company of Mr. McCarthy, who happened to be the deputy to Mr. Nguka at that time. It was then agreed between Mr. Nguka and Senior Counsel Naidu that TINT Pty Limited and its representatives would make efforts to request Mr. Tetard to adduce an affidavit to say that he was the author of the encrypted facts. Later in that day, in discussions with both Mr. Dryman and Ms. Guria as to what the encrypted facts entailed, they said that they saw a crumpled piece of paper in Tetard's handwriting, allegedly, together with the transcript in a typed form. Now, we then proceeded to Paris and had intensive discussions with Mr. Perrier, Mr. Tetard, Mr. Yande Jamaron joined us for the first time, as well as Ms. Guria, accompanied...
Sorry, when was this then?
It was around late April 2004.
Again, before the trial started?
Yeah, the trial was scheduled for 10th of October 2004.
Mr. Sooklal, before you proceed, can I ask you about the code referred to in the encrypted facts? Just for the benefit of the tribunal, I mean, what was that code?
As I intimated that since September 2003, I was involved in this matter right up until October 2009. And during my various interactions with Mr. Tetard, on an occasion in about 2006, on a beach in Mauritius, and Mr. Tetard was then a visitor to Mauritius, as he had since returned to the Paris head office, and Mr. Jamaron took over his managing directorship in Mauritius. So while sitting with Mr. Tetard on the beach in Mauritius, I had a discussion with him about the encrypted facts and the issue about the code. And he intimated to me that the code was given to him by JZ, as mentioned in his facts. And the code was, when he entered JZ's residence at King's House in Durban, JZ intimated, uttered the words, I see the lights are shining brightly on the Eiffel Tower tonight. So the code is the Eiffel Tower.
Thank you. You were speaking about the meeting in Paris.
So we met Mr. Tetard in Paris. After much persuasion, he put up...
So now we're now back to
April 2004.
2004.
Yes. So in April 2004, Ms. Teta then put up an affidavit. And do you want me to read it here?
Sure. If it's not too long, I think that would be
page.
appropriate. Yes.
Okay. So it's an affidavit in Mr. Teta's handwriting, and it commences as follows. I, the undersigned, Elaine Tetard, care of Thales, of 45 Rue de Villiers, postcode 92526, Neuilly, spelled N-E-U-I-L-L-Y, CEDEX, C-E-D-E-X, France, hereby attest the following. 1. I was born at Sidi Bel Abbas, S-I-D-I-B-E-L-A-B-B-S, open brackets, Algeria, close brackets, on the 6th of March, 1948. I have examined a copy of the document which is annexed here to an initial by me and marked X. 3. I confirm that I am the author of the said Annexure Act. Made in Paris on this 20th day of April 2004, and it bears Mr. Tetard's signature, and it is made before an apostille, which is similar to a commission of oaths. And subsequently, this document was delivered to Mr. Nguka.
Thank you.
The document was delivered to Mr. Nguka's office and received by Mr. McCarthy on the 26th of April 2004 at 14:31. So matters move along, and we were instructed by Mr. Perrier upon receipt of a letter by Mr. Nguka to the effect that upon delivery of the Tetard's affidavit to the NPA, Mr. Nguka confirmed in writing that charges against TIN Pty Limited will be withdrawn at the next trial date of Mr. Sheikh, that was the 10th of October 2004. At that time, Mr. Perrier was still unhappy with the state of events after receiving the Nguka letter, in that he said that there were warrants of arrest issued by the then Scorpions, and it became an Interpol warrant, and the warrants were against Mr. Perrier and Mr. Tetard. And he asked that Mr. Nguka withdraw these warrants, to which Mr. Nguka then acceded to. Furthermore, Mr. Perrier intimated that between April 2004 and 10th of October 2004 was rather a long time, in that it was affecting the business of the company worldwide. The reason why it's worldwide is because Thales SA Paris employs 65,000 people worldwide with a huge multi-billion euro turnover, and coincidentally Thales SA employs 800 in-house attorneys worldwide. Now matters moved along until the 10th of October 2004 dawned, and at the commencement of trial before Squires J, the presiding prosecutor requested that charges be withdrawn against TIN Pty Limited, and the charges were duly withdrawn, whilst the Sheikh trial proceeded thereafter.
Thank you. And as far as the withdrawal of the charges are concerned, I assume that Thales SA whether through Perrier or Moino or both, would have been quite pleased, because if I understand matters correctly, there are international implications which include the Foreign Corrupt Practices Act that they may have been facing if those charges did proceed.
That is correct.
Thank you. So the charges were withdrawn.
That is correct, and the Sheikh trial resumed.
Yes.
And Mr. Sheikh was duly convicted around June 2005. And subsequent to the conviction and sentence, the NPA moved to attach Mr. Sheikh's 20% equity held in Tint Pty Limited. That 20% equity eventually, with the assistance of the curator appointed by the NPA, though that 20% equity was then sold back to Tint and the Thales Group for the amount of 39.3 million rand. After the conviction and sentence of Sheikh, around August 2005, the NPA saw fit to issue various search and seizure warrants. Now, what had happened after the conviction of Sheikh is that President Mbeki decided to dismiss then Deputy President Zuma from office, and this happened around June 2005. And subsequently, Mr. Zuma appeared in the Durban Magistrates Court and was granted bail of 1,000 rands. In about August 2005, the NPA searched 19 different addresses throughout South Africa, including government buildings and private residence, including that of Mr. Zuma and Mr. Sheikh and others. And for the first time, both Mr. Moino experienced a search and seizure on his residence as well as on his offices in Pretoria. Mr. Moino was quite aggrieved with this sequence of events. I was still in Durban, and he called me to say that I needed to proceed to Pretoria to request the NPA personnel as to why they were conducting search and seizure. When I came up to Pretoria that day in August 2005, the NPA were busy in Mr. Moino's offices with various personnel rummaging through documents, and there was one gentleman who was downloading the hard drive of Tint Group from the Tint offices. So that search and seizure in the office commenced at about 9:30 a.m., according to Mr. Moino, and it concluded at about 5:30 p.m. After Mr. Moino and his secretary signed off the various documents that were seized, the personnel from the NPA then left the office. And as it was a tiring day, Mr. Moino said that we need to go home, and I intimated that it was high time that we leave. He then said to give him a minute, and he was going to his motor car in the basement parking, and he'll come back. So I sat in his office. He proceeded to his motor car, and he came up with his brown satchel, and he then said, I'm going to give you something, and this is what the NPA is looking for. So he gave me a document, and I read through the document, and then I asked him, what is this document about? He says, well, this is an agreement that the NPA is looking for. It's an agreement which was entered into between Tetard and Sheikh, whereby Tetard agreed to pay Sheikh a consulting fee in respect of work to be done to lobby to obtain the tender for the polycarbonate driver's license tender that was going to be issued by the Department of Transport. At that time, the then Minister of Transport for that tender was one Mr. Mac Maraj. So in discussion with this document, Mr. Moino confirms the signature of Mr. Tetard and Mr. Sheikh, and it was well known that it was the signature because Mr. Sheikh's signature as well as Mr. Tetard was proven during the Sheikh trial in other documents. And that document that I discussed with Mr. Moino at his office in August 2005 was in fact a bribe agreement that Tetard entered into Sheikh, whereby Sheikh, through his Swiss bank account, received a sum of money which was mirrored in the bribe agreement, and that exact same sum of money enumerated in the bribe agreement was paid into Mr. Sheikh's account in Switzerland. Mr. Sheikh's account, upon receipt of that money, then transferred that money to one Zarina Maraj, who was Mr. Mac Maraj's wife. And the same amount of money was passed to Zarina Maraj's account. What is interesting is Sheikh's account and Ms. Zarina Maraj's account have consecutive numbers. So it intimates that they were opened at about the same time at the same bank in Switzerland. Subsequently, Ms. Maraj then took that sums of money and put it and then transferred it to a British tax haven in the Isle of Man, through her bank in the Isle of Man called Allied Dunbar Bank, and she transferred all that monies away.
Thank you. Mr. Sooklal, you've been speaking about Mr. Tetard. There's a photo that is up behind you. Can I ask you to identify, if you don't mind turning around, whether Mr. Tetard is in the photo, and if so, who he is?
Mr. Tetard is in the white shirt on my left.
On your left and on the right of the people sitting in the tribunal. Okay.
He's a gentleman in the white shirt.
Okay.
And that's the first time South Africa is seeing Mr. Tetard's photo. No media has seen his photograph.
Why is that the case?
It's because Mr. Tetard always claimed that he was a private person and that no one should, his photograph should not be seen, because it then becomes very easily available to Interpol, because in 2005, Mr. Tetard, the NPA had issued the Interpol search arrest warrants against Mr. Tetard, which was subsequently withdrawn in April 2009, where charges were withdrawn. Now, Mr. Tetard is a very important player, as I've indicated. Mr. Peria, Mr. Moino, Ms. Guria, and Ms. Guria's immediate supervisor called him Mr. Thomas. But we'll get into that in a moment.
Thank you. Can you then return to Mr. Maharaj?
Okay. Respect of that bribe agreement, the NPA had then sought mutual legal assistance from the Swiss authorities, and after much opposition by Mr. and Mrs. Maraj as well as Mr. Sheikh in the district court of Zurich, the court gave a final order on the 17th of December 2004, where it updated the request for judicial assistance by the Directorate of Special Operations, Pretoria, South Africa. And it's versus Shabir Sheikh, born on December 10, 1956, citizen of South Africa, address Victoria Main 502, Durban 4000, South Africa, represented by attorney at law Godens F. Dominic, address Praga Dreyfus, Muller Buckstraat 6, Zurich 8008, and the affected parties are Mindeli Investments Incorporation, Pasio Estate, Road Town, Totola, British Virgin Islands, and the other party is Maraj Zarina, 30 Second Road, Hyde Park, RSA-Johannesburg, code 2196, concerning judicial assistance for the Republic of South Africa, open brackets, corruption offences, close brackets, based on the following reasons. The Directorate of Special Operations is conducting criminal investigation against Shabir Sheikh based on the following facts.
And sorry, Mr. Sooklal, the companies that you mentioned, who were they controlled by? Mindeli Investments?
Mindeli Investments was Mr. Sheikh's company, which had the bank accounts in Switzerland.
Okay.
Do you want me to read the whole judgment? It's quite long.
Maybe if we have some extra time at the end of the day.
May I give you a snapshot?
Sure.
Okay. The judgment reads as follows. With the updated request, the South African authorities asked to make documents regarding the account of Mindeli Investment Corporation with Bank Alliance SCS in Geneva available. With the order of the District Attorney Office, Canton of Zurich, 20th April 2004, Bank Alliance SGS was ordered to produce documents regarding said account. The bank complied on May 27th and June 3rd, 2004. It can be gathered from the documents that Mindeli Investment Incorporated was the holder of account number 95436 with the above mentioned bank. The account was opened on October 11, 1996 and closed on March 26, 2002. According to the relevant forms, Mr. Shabir Sheikh was the beneficial owner of the account. Only 2 incoming money transfers were recorded. They're in columns here for panel members' information. The one heading is value date, then the amount, then the transferring bank, then the instructing party, and the number of document. The first date is 11th October 1996 for 600,000 French francs from Banque Paribas, Paris, to the instructing party, one of our clients, and the document number. Now, the instructing party, one of the clients, is the Thales Group, based on the bribe agreement entered into between Tetad and Sheikh. And that payment was made by a sitting MP in the French Parliament, who at that time was an official of Thales. The next date is 11th of March 1997. It's also for an amount of 600,000 francs, but this was converted into US dollars denomination of 103,626.94 cents. Again, Banque Paribas, Paris, instructing party, one of our clients, and the document number. Immediately after the bank transfers, the account of Mindeli Investments Incorporated was debited with the following. On the 16th of October 1996, with an amount of 111,111 rands and 11 cents from into the bank SCS Alliance Geneva in favor of account number 95437. Again, on 13th of March 1997, the receipt of 100,000 US dollars, again with the bank SCS Alliance Geneva, 95437. According to the judgment of the Swiss Federal Supreme Court of April 15, 1999, the pleas as contained in the request for judicial assistance may not be interpreted conservatively. It then shows the money flow, and as I intimated that the account number 95437 with Bank SCS Alliance is registered in the name of the South African citizen Zarina Maraj, who is the beneficiary of the account. The account was opened on October 14, 1996 and closed on April 6, 2000. The account was credited with the 2 credit transfers from Mendeley Investments Incorporated. The following payments were made out of the said account of Zarina Maraj. On 22nd of October 1996, $96,000 was transferred to Allied Dunbar Bank of the Isle of Man in favor of account number 11444107 under the name Maraj. In the following payment on the 10th of April 1997, the amount of $65,000 was transferred to Allied Dunbar Bank, Isle of Man, in favor of account number 11444107 in the name of Maraj. The account was balanced with the value date of March 31st, 2000, and a check was written out in the amount of USD $54,268.05 payable to Zarina Maraj. And that basically was the amounts of money that were transferred from Thalers to Sheikh to Zarina Maraj. Now, what's interesting is that has to be read, as I said, with the bribe agreement. And I'll come back to that in a moment. So this bribe agreement, the heading is ID Matics SA, which is the subsidiary of Thales SA. The agreement is addressed to Mendeley, British Virgin Island, and it is marked confidential group. It got a reference number, and the date there is July 5th, 1996, and the subject is R.S.A-driving licenses. And it says, I'm going to give a snapshot of this agreement because it's rather long. We hereby confirm the terms and conditions on which we are prepared to appoint you as our consultant regarding direct sales by our company, hereinafter referred to as a contract, to the Department of Transport. And it gives out the mandate of Mr. Sheikh, what he is to do. And subsequently it says, in addition, as from the effective date of this agreement, our company will pay you, subject to the terms and conditions of the agreement, a remuneration of 1,200,000 French francs. And this is the same amount of money that was transferred to Sheikh's Swiss bank accounts. It is signed and bears the signature. It says ID Matics SA, it bears the signature of A. Tetard, and it's typed in A. Tetard. And the agreement then says that to confirm your agreement, please return this letter duly initial and bearing your signature, preceded by the handwritten mention, read and approved. And in handwriting, it's written read and approved, and the signature of S. Sheikh appears thereon.
Thank you. It's correct to say, is it not, that the Scorpions then got wind of this?
Now, what's correct to say is that the judgment from the Swiss court was forwarded, the authentic order was forwarded to the Scorpions at the time the judgment was issued. And when it came to Pretoria, the Scorpions did nothing about it. There became no inaction. We only learnt about this document is on the 29th of September 2017, when in the Supreme Court of Appeal, Ponent J.A. gave a judgment in the matter of MNG versus Maraj and others. And especially at paragraph 38 and paragraph 39 of Ponent J.A.'s judgment, the court there makes a clear case as to why the NPA is not prosecuting the main offenders in this bribe agreement. And the main offenders in this bribe agreement are Tetard, Peria, Sheikh, and the Talas group on the one side, and Mr. and Mrs. Maraj on the other side. And it's a high time that a panel like this needs to ask the head of the NPA as to why no prosecution is flowing from this Swiss judgment on the basis that under a subpoena duce is taken, my legal representative has submitted a copy of the bribe agreement to one advocate Jiba, then acting director of the NPA, where the bribe agreement was annexed to the subpoena in respect of a pending matter. Ms. Jiba, in turn, upon receipt of this bribe agreement, and as she had already had in her NPA files the Swiss court order, she simply asked the state attorney to respond to the subpoena by saying that it was a private contractual dispute, and therefore this bribe agreement plays no part with the NPA, and therefore the subpoena should be withdrawn.
So the NPA then remains supine despite the facts that you've just described?
Yeah, a thoroughly supine approach by the NPA. We see more and more in the media, even yesterday, about efforts being made to prosecute Zuma and the Thales company on the one hand, but the NPA does nothing when it is armed with documentary evidence directly implicating the French as well as the Maraj family and Mr. Sheikh. Now, more especially why I say this is because as I read out, the bribe was paid in US dollars. It's for the US judicial authorities through this panel to alert them to say that why are you not looking into this in terms of the Foreign Corrupt Practices Act? The other issue that arises is that Ms. Maraj transferred this bribe money into her Allied Dunbar Bank account. It falls within the jurisdiction of the UK authorities, especially the Financial Conduct Authority. So it's up to this panel again, together with interested NGOs, to seek the assistance of Lord Peter Hain and others, to ask the Financial Conduct Authority of the UK as to why they're doing nothing about these illicit money flows.
Thank you. Is there anything else that you wish to tell us about Ms. Jiba, the acting NDPP at the time, in regard to, I mean, was there ever an application to compel disclosure of the information that she had, and can you tell us any more facts around that?
No, I don't have.
In that case, let's move on to where some of Thale's money went, if we can. There were donations that were made to the ANC as well, were there not?
Okay, maybe in a time sequence. We have the Sheikh trial commencing in October 2004. Subsequently, Mr. Sheikh was imprisoned, and his business was then run by his brother-in-law, Mr. Yusuf Wahid. And in a letter dated 28 June 2007, addressed to Attorney Reeves Parsi, who was the attorney for Mr. Sheikh, I still presume he is, Mr. Wahid had marked a letter called extremely private, and on this 28th of June 2007, Mr. Wahid writes to Mr. Parsi, querying a senior counsel's bill, which senior counsel was mandated to act for separately, of course, for Mr. Sheikh and separately for Tint Pty Limited. And it seems like the query was that senior counsel was working up to 27 hours a day, so therefore the query.
How much?
if you look at the bills of senior counsel, you'll see he was working flat out for 27 hours a day without having any meals or even visiting the bathroom.
And there was still an extra 3 hours in the day.
And the bill was subsequently reduced, by the way. But more importantly, Mr. Vaya's letter mentions this paragraph, and it says, you'll have to meet with him, that senior counsel, as soon as possible, and I agree with you. Say to him that you uncovered this duplication whilst the French were helping us with legal fees in our matter upon checking and comparing the various bills. So here we see the French paying Mr. Sheikh's bills. Subsequently, as I shall refer to the Swiss court order and the attorney and counsel employed in Zurich, I was introduced by Mr. Moino to a senior counsel called, and I'll refer to his name in a moment. His name is Neyrud, S.C., N-E-Y-R-O-U-D, practicing in Geneva, Switzerland. And Mr. Neyrud and Mr. Moino went to school together. And Mr. Moino intimated that he was paying all the bills of Mr. Sheikh and the Maraj couple in the matter in the Swiss court in Zurich. And there are documents to prove that Mr. Neyrud has sent emails to me where he was grumbling about not getting paid on time by the Thalers group, and subsequently Mr. Moino and Ms. Christine Gouria paid off these amounts. But Ms. Gouria, Mr. Moino, as well as Ms. Gouria's supervisor, Mr. Thomas, as you can see, are all accomplices in this matter of Maraj.
So the Thalers group, as you've just said, was funding Mr. Sheikh and Mr. Maraj's defense overseas. Can you tell us more about funding to the African National Congress by the same group?
Then about 2006, in South Africa was holding local government elections. And Mr. Mzimang, I mentioned him earlier, being the Treasurer General of the ANC, he intimated that he'd like a donation from Mr. Peria.
Sorry, he intimated that you're swallowing some of your words.
Mr. Mzimang intimated that he would like Mr. Peria to make a donation to the ANC. That donation was then facilitated by Mr. Moino, and Mr. Moino was given a account of a trust company for on behalf of the ANC, and this Mr. Peria then authorized a donation to this trust company. The check that was drawn for this donation of 1 million euros was drawn by a friend of the Thalers group based in Dubai, and that check from Dubai was handed over to Mr. Mzimang at his Pretoria residence, for being the donation of 1 million euros.
So you saw that yourself, firsthand?
Yes.
Thank you.
Then subsequently, as I said, we enlisted the support of Mr. Maduna when charges were withdrawn. And in August 2005, when search and seizure operations were conducted at 19 places in South Africa, Mr. Moino intimated that he would like to enlist the services of attorney Maduna, who was now in private practice, to find out why search and seizure was done on his home and residence, on his offices. Mr. Maduna agreed to meet Mr. Moino and Mr. Peria at a hotel in London. This was in 2005. Mr. Maduna was accompanied by his wife. The air tickets were paid for by Mr. Moino, and subsequently the discussion took place between Mr. Moino and Mr. Maduna. 50,000 euros in cash were handed over by Mr. Moino to Mr. Maduna. No receipt was issued, and a meeting subsequently ensued with Mr. Peria and Mr. Moino in London, enlisting Mr. Maduna's services on the basis that Mr. Perrier wanted further representation to be made to the NPA, but nothing really came of it. What's interesting for the panel is there Mr. Matuna gets paid 50,000 euros in cash. And when he was departing the hotel the same evening, he called me to say he wants to see me. So I went up to see him. He said he was going to take a underground tube train to Heathrow Airport to get onto his flight to Johannesburg. And he made a most astounding statement. He says, he's short of £3.50 for the tube train, and can I give him that money? And I was astounded at this, and I declined to give him that money, inasmuch as he had 50,000 euros in his pocket.
Yes. So you've now mentioned that there was the €1 million payment to the ANC, which you saw, and the payment of 50,000 in cash was something that you also personally saw.
Yes, and then in about March or early April 2007, Mr. Zuma wanted to make a trip to Europe to meet various parties. I had arranged a trip, and we went to London, and then we went to Brussels. And in Brussels, Mr. Moino called to say he was in Paris, and he will take a fast train, and he wants to meet Mr. Zuma. When he came up to Brussels, he had a chit-chat with Mr. Zuma in the hotel room, and Mr. Moino then proceeded to pay Mr. Zuma 25,000 euros in cash, and he went downstairs, and he settled Mr. Zuma's hotel bill. And then there are many other occasions. In October 2007, Mr. Zuma went to Paris for the Rugby World Cup, and his clothing did not arrive. And then Mr. Moino agreed to buy a new wardrobe to Mr. Zuma, who went on a shopping spree in Paris and spent, Mr. Moino paid quite a bit of money for that. Mr. Moino also paid for the hotel stay of Mr. Zuma at that Rugby World Cup stint.
Okay, and so this seems like a pattern of behavior. I mean, is that's the impression that I get from your evidence? Is that incorrect? These illicit payments being made?
Mr. Moino always told me in my 6 years relationship that I shared with him that he had carte blanche amounts of money in order to ensure that this problem of tint goes away, and it doesn't rear its head in any form or shape. And he always had loads of money dishing out. He even intimated to me on very many occasions, on more than one occasion, of his own volition, that he says, I don't know why they're making a big noise about this arms deal, because Chippy Sheikh, my good friend, this is Mr. Moino's words, he got paid $3 million by the Germans, and I personally, Mr. Moino, I paid Chippy Sheikh $1 million in cash.
This is Moino that said this to you?
Yeah, on many occasions.
Okay. Okay. Sorry, Mr. Sooklal, and particularly the panel, I know that we have a specific program, but given the importance of this witness, I wonder whether I might ask for another short adjournment to finish the witness's testimony before questions are asked.
My team like you a great deal, it seems like. They're being very indulgent, so here we go. You have more time.
Thank you, Member Jacob. Yes, of course, Member Jacob. Thank you very much. Mr. Sooklal, before we broke for the adjournment, you mentioned that Moino told you that he paid €1 million to Chippy Sheikh. Is that right?
No.
Okay.
No. Mr. Moino paid $1 million to Chippy Sheikh.
Sorry, then I got the denomination wrong. Thank you very much. what I really want to ask about in regard to that is why is it that Moino seems to have trusted you so much? I mean, the payments that were being made sound as though they were illicit. Why did Moino and or Thales trust you? What was your role within Thales?
Mr. Moino wanted directions as to how to proceed in the South African government environment, as well as...
Could you speak more closely?
Please,
Okay,
move into
thank
the
you.
microphone and try and speak a little bit more slowly.
Mr. Moino had trust in me because he had done a long background check before he approached me in September 2003. And when he saw my interactions with various ministers during our trip to India in October 2003, as well as in November 2003 in Paris, and on various other occasions, he knew that I was a go-to guy for him to ingratiate himself.
Thank you. And as far as payments for legal fees are concerned, can you expand, please, on what Thales was willing to pay for and for whom?
Mr. Moino's refrain from 2003 until 2009 was that money is no problem. He says that as long as we get good results, Mr. Perry has instructed him that money is no problem in order to overcome the legal obstacles that Tint and Thales were facing in South Africa. Now, for example, there were ongoing litigation in the Republic of Mauritius. During search and seizure operations by the Mauritian authorities, together with lead prosecutor in the Sheikh trial, Billy Downer, who was present in Mauritius, the Mauritian authorities conducted search and seizure operations on Thales' offices in Port Louis, Mauritius, as well as Mr. Tetard's residence and other officials of the Thales group based in Mauritius at their residence. One of the documents seized was an affidavit of, not an affidavit, but a diary of Mr. Tetard. And this diary later became a bone of contention during the Sheikh trial because it contained entries about when Mr. Tetard met with Sheikh and when he met Mr. Sheikh together with Mr. Zuma at King's House in Durban. So this diary was seized by the Mauritian authorities, and strenuous efforts were made by the Thales group not to allow the diary to be introduced into evidence in the Sheikh trial. Also, there were other documents that were seized in that raid that became pertinent to the trial of Mr. Zuma and tin companies later in 2005. And efforts were made to stymie the production of those documents in a South African court of law. So separately, Thales Africa Mauritius enlisted the services of one QC called Hamid Mulan, assisted by 3 junior counsels, to assist them in their endeavors in the Mauritius Supreme Court. And Mr. Zuma, through his attorney Michael Hulley, separately enlisted the services of Mohammed SC to act for Mr. Zuma in the Mauritius Supreme Court proceedings. Subsequently, Mr. Mohammed SC requested to be paid after quite a stint in providing services to Mr. Zuma's legal woes in Mauritius. And Mr. Moino was approached, and he then went off to Maputo to see an old friend of his, according to him. His friend was Mr. Jacinto Veloso. And Mr. Veloso was a very high-ranking member at one time of the Frelimo party in Mozambique. Mr. Veloso was also well known to Mr. Zuma. After that visit to Mozambique, Moino and I flew to Mauritius, and we met Mr. Hali with Mohamed SC, and arrangements were made between Hali and Mr. Moino to pay Mohamed SC, and Mohamed SC agreed on the payment scheme that Mr. Veloso will do, and all that was done in due course, which was, as I said, that entire litigation was paid by the Thales Group.
Thank you. And were these, the Mauritian legal fees, the only legal fees that were being financed, whether directly or indirectly, by Thales in its various manifestations?
As I alluded to earlier, all legal fees where Thales was involved in, whether in the Maraj matter or the Zuma matter, and as I read out earlier an excerpt of a letter from Mr. Wyatt, all the legal fees were being paid by the Thales Group.
Thank you. Then, in regard to the Sheikh trial, did Mr. Moino give evidence there?
Yeah, Mr. Moino gave evidence for the defense. What was interesting is that after the close of Mr. Sheikh's evidence, his counsel, senior counsel found it necessary that there had to be witnesses from the Thales Tin Group to give evidence for the defense. So arrangements were made to go to Paris. Mr. Sheikh's legal counsel and attorney, together with Naidu SC, all flew to Paris, met Mr. Peria on a Saturday, and Mr. Peria declined that any official from Paris would give evidence. The only official that was requested to give evidence was Mr. Moino, because he was based in Pretoria. So he duly gave evidence, and we must take note that Squires J, in the Sheikh judgment, in as much as declining Mr. Moino's evidence, intimated that Mr. Moino's evidence was given with Gaelic candor.
And what did you take that to mean?
Well, I suppose to a layman, Gaelic candor is that it seems like French-speaking people do not speak the truth.
Okay. In regard to the payment of Shabir Sheikh's legal fees, do you have any proof of those payments being made?
No, I articulated in Mr. Wyatt's letter earlier on that Mr. Wyatt was imploring Mr. Reeves Parsi, Sheikh's attorney, to implore on senior counsel that the fees were being paid by the French. The French, for all intents and purposes, be it Mr. Sheikh or his representatives, or Mr. Zuma and his representatives, meant the Thales Group.
Okay. Now, you've mentioned, in as far as that correspondence is concerned, I just paused to point out that the panel will be provided with copies of that correspondence in due course. You've spoken about Mohammed SC in Mauritius, but Naidu SC was someone who you've also mentioned. As I understand it, Naidu SC represented Tint and Zuma in legal proceedings in South Africa. Is that correct?
That's correct. Early in 2003, the then DSO had submitted a set of questions for Mr. Zuma, who was at that time the Deputy President of the Republic, to answer. And he enlisted the services of Naidu SC to answer the questions. So subsequently, when I had requested Naidu SC to get involved with the 10th Thales matter in early 2004, he had to seek the consent of Mr. Zuma that he had to, he was no more acting for Mr. Zuma, and Mr. Zuma consented to Naidu SC acting for the 10th Thales Group in the forthcoming trial with Sheikh.
Okay. I'd like for you to comment in that regard. Well, in the first place, your understanding, although the advocate may have changed, was that Tint or Tales were effectively still financing Mr. Zuma's legal fees.
Can I just say you've been told that we have to leave at 12:45. You have 3 minutes, right?
Thank you, Member Jacob.
And we'll come back at 1:45 and carry on.
Thank you.
As I said, Mr. Moino had this carte blanche authority to pay everyone's legal fees or other matters arising, and he always paid on time whenever a bill was sent to him.
Okay, thank you. I think, Member Jacob, that would be a good place for us to stop, and then we will complete the questions to Mr. Sooklal after lunch.
We look forward to seeing you again at 1:45.
Thank you.
Thank you. Thank you, Member Jacob. The one additional thing that I wished to say is... Okay. Sorry, swapping microphones again. The one additional thing that I wish to say about this witness is that I have already said that the witness is here as a whistleblower, is here voluntarily. We both agree on that. The witness is willing to answer questions that go to the substance and content of the evidence that he has given. However, there are certain other questions to which I've alluded to that the witness is not willing to answer. If we can proceed, I know that I cannot prevent the panel from asking any question that it wishes to, but to the extent that those questions stray from the substance and content of the evidence in Mr. Sooklal's affidavit, Mr. Sooklal is not willing to answer questions that stray outside of that.
Yeah. Look, I mean, I repeat that all Mr. Sooklal has to say is that I refuse to answer the question, and we shall treat his answer with respect. We might ask him why, and if he refuses to answer that question, we will treat that with respect too. Is that fair enough?
Yes, Member Jacob, thank you.
Thank you. So, Mr. Sooklal, let's go back to where we were. So, I'll give you another chance to answer that question because you may have been tricked. Were you or were you not upset when you saw from the judgment that your boss and Jacob Zuma were both very likely corrupt?
With respect, I don't see the relevance of answering that.
You're not answering that. Okay. Do you still insist that you only got to know about the morality of Jacob Zuma and Tint in 2005? Or do you not want to confirm that either?
I don't see the relevance of that to my substantive evidence.
I think it is for us to determine relevance. It's for you to decide. You see, let's just understand each other. I do not think you have the power to determine relevance. Hold on. Mr. Stubbs, do you want to argue relevance here?
Argue the relevance?
Yes, he says he doesn't think the question is relevant. Now, if you want to argue that the question is irrelevant, you may do so.
The question that was put to Mr. Sooklal...
The question that was put just now,
yes,
where he says it is not relevant.
Yes.
Do you want to argue irrelevance, or do you want to leave it there?
Before I answer that question, may I ask Member Jacob if you would remind me of what precisely the question was?
Yes, precisely the question was whether he still sticks by the answer that in 2005 he was upset to learn that, which is the question he gave, and I gave him an opportunity to withdraw it, that in 2005 he did come to the realization that his boss and the deputy president were both on indication immoral and corrupt. He says that is not relevant. Now, you can argue it now, but in the future, every time he says the question is not relevant, if you don't argue it, shall I assume that you don't want to argue it, right?
I think that that's a safe assumption for you to make, Member Yaqub. In this instance, I cannot argue that the question itself is irrelevant. What I would submit, though, is that the question has been asked and it has been answered.
What you would submit is that?
The question has been asked and it has been answered.
No, no, no. It was answered before. I'm asking you a different question. Does he still stick to that position, or is he changing? Because remember, he can now withdraw any answer. And I've got to give him that opportunity in the light of the new circumstances. So I didn't ask him the question about, do you still stick to your position in regard to this? I asked him a question in regard to this, and now I'm asking him whether that is still his evidence or not. And that is relevant in the light of all the circumstances. You can just tell me either that that is true and he sticks to that evidence, or he can tell me he doesn't want to answer that question. What he can't say to me is that it is not relevant. Do you accept that?
You and I, we agree that relevance is not something that can be raised.
Right.
As I've said, yes.
Okay, so you're not arguing relevance at all, and you withdraw the submission that the question has been asked. Because it's not been asked. He was asked the question, did you get to know in 2008? And he said yes, for the first time, that they were, and I want to ask him whether he confirms that. Now, I didn't ask him before whether he confirms that. So do you concede that that question is not a repeat question, and do you withdraw that point?
I appreciate the question, Member Yaqub.
Thank you.
But I am unfortunately constrained not to concede that. Perhaps you can assist me. To my mind, to ask a question and then to ask the question of whether the person confirms the answer to the previous question.
Tell me what's the unfairness of it, because if he confirms, he just confirms, that's the end of that, and he faces the consequences of that confirmation. If he doesn't confirm, we leave it, and if he doesn't answer the question, we leave it. I just can't understand the unfairness that you're relying on.
I did not suggest that it would be unfair, or I did not explicitly argue that it would be unfair according to a specific standard. What I'm trying to do to protect my witness in what appears to be a procedure akin to cross-examination is to ensure that he need only...
him questions, and he's not obliged to answer any questions. He will face no prosecution as a result of failing to answer questions. He will face no prosecution in regard to... He is an absolutely free man. He can leave now. There's absolutely no compulsion on him.
Yes.
I repeat that completely, that if he finds these proceedings no good, if he doesn't want to answer questions frankly and honestly, and if he chooses to leave now or at any time, he must just do so. That's fair, isn't it?
That is fair, Member Yaqub, but
Completely
I was addressing
fair,
a different
I would suggest
issue.
to you.
Yes, yes,
Right.
I accept that.
So can we carry on?
Well, Member Yaqub, I was in the middle of an answer to the previous question, which does not go to the question of what it is that we covered with you a moment ago. What I was trying to understand before we first adjourned some time ago now was the manner in which I am entitled, in as far as you're concerned, to protect the witness as you asked me
to work out whether this is an honest whistleblower. That's all.
I accept that, Member Yaqub.
That's all. And I think that all the questions, and I have to know, particularly when there are indications of dishonesty, and you will be the first to admit that there have been many so far. I'm not saying he's dishonest. I'm saying there have been indications of dishonesty, and indications of dishonesty on the part of a witness of this kind must be tested if we are to make anything of it, on the basis, again, that there are no consequences, criminally or otherwise, for him. He cannot answer questions, and he can go away now. By the way, can I ask you one question? If you can take instructions, it's somewhat important. Did your Did the tribunal organizers approach him, or did he approach the tribunal organizers? Because that might make a little difference to the scheme of things.
I may need to take instructions on that.
Can you please take instructions immediately? It's quite easy to find out.
I shall do so, but seeing as it will take some time for someone to give me the instructions, if I could perhaps finish my answer.
Right, yes.
Thank you. So, what I asked at the very beginning stage of this aspect of the proceedings was, to your question, Member Yaqub, as to whether I would protect this witness or not. And I agreed that I would protect this witness. What I asked, and what has not been answered, is in what manner am I entitled to protect this witness before this tribunal? May I protect this witness as if he was my client, which he is not, and as if he was my client subjected to cross-examination from my opponent, in which case, if he has answered a question, that is a basis for me to object to him being asked it once again.
You can object. You can object to what you like, provided we make the decision on your objection. You can object to every question if you like, and after that we decide. Then you can say you don't accept it and you want to object again. So, like the witness, you are not held to anything. You are also absolutely free to do exactly as you choose.
I hear that and I appreciate it, Member Yaqub. There's just one difficulty that I have, which is that, well, perhaps if I could ask you for a moment to imagine proceedings that are adversarial.
Proceedings that are?
Adversarial, unlike these proceedings. If my opponent has a witness in the box, my witness, and my opponent is cross-examining my witness, and my opponent asks a question that I think is unfair, I object to the question, but my opponent does not decide the merit or otherwise of my objection. The difficulty that I have in these proceedings is that it is not clear to me the extent to which I can protect the witness. If you are saying, if you, Member Yaqub, are saying that I can object as many times as I wish, I do appreciate that opportunity.
Can I ask you then to go appoint, if you can, an opponent of your choice? We have been very patient. I think we have been fair on these things. But if you think that you are prejudiced because you don't have an opponent, we don't be unfair on you either, speak to your organizing committee, get an opponent to assist, and we will make sure that we get then the appropriate argument on both sides every time you raise a question. And of course, I will talk to your opponent about it as well, and we'll talk to each other. But if your submission is that it is unfair that you don't have an opponent, then please, and the allegation you're making is that we are the judge and the jury and everything rolled into one. You see, these are not adversarial proceedings. These are inquisitorial proceedings. You, because of the nature of those proceedings, have got away, as you know, with evidence which in adversarial proceedings would have been shut down in half a second. I would suggest that 3/4 of the evidence you have led so far falls in that category, and you have been benefited getting away with it, right, at that level. All I'm saying to you is, you can't have your cake and eat it. If you want it adversarial, then tell us, and if your clients want it adversarial, tell us, we'll make the appropriate arrangements, you start your evidence again, and we will treat it as if it is adversarial. If it is a serious matter, because you can't have it both ways, so do you want it adversarial or do you want it inquisitorial, because both of which have their troubles. If you want it adversarial, then again it's your choice. You start again, and we will treat the proceedings as adversarial and make sure that you are held to account at every level.
Yes, Member Yaqub, I appreciate that.
Would you like it to be adversarial?
No, Member Yaqub, I never...
Are you sure?
I never suggested that I would like for it to be adversarial, nor did I suggest that...
No, but you can't. You can't have your cake and eat it. You accept that? You can't have the
Of course I accept that, Member.
You can't have the benefits of an inquisitorial process and not have the ill consequences of it?
Absolutely.
Absolutely. So now, where do we go from here?
So, Member Jacob, what...
So you made the complaint, and I want to hear you, because if you maintain that complaint, that you are in trouble because of the improper way in which this panel has conducted itself in relation to you and your client being the judge and jury all in one, you must make written submissions to that effect. We look at them very carefully and decide, because if we have reached that stage, in a sense, we too are free. As you are free, as Mr. Sooklal is free, you make your submission, and we'll be, if necessary, withdraw from these proceedings as a panel, and it can start again. And make no mistake about it, if you have serious problems with the panel, say so, and we will have 2 more free days, which would be very nice. So I think you need to make you made an allegation of unfairness, and if you don't want anybody in the panel, say so, make your application, don't make allegations on the sly. Face the allegations you make, face the consequences of it, and do it now.
Thank you.
Or if you want some time to think about it, you have that time too.
Thank you, Member Jacob. I think that I need to take some time to clarify the submissions that I've made, because with respect, it sounds as though you haven't understood them the way that I meant them. I haven't raised a complaint of unfairness or a complaint of any kind whatsoever. I have merely raised a question as to the extent of the protection that I can afford this witness, who is not my client,
well, at the moment,
in these inquisitorial proceedings.
Okay, and I've told you that you can afford as much protection as you can, and we'll decide. In response to which you raise the question of not having an opponent and so on.
No.
So I think you really have to make a decision about, you know how the land lies.
No,
do you want to go ahead or don't you?
I didn't raise the question, Member Jacob.
But I'm
posited a hypothetical.
Just tell me straight. Let's not get involved in an argument.
Okay.
Shall we go ahead? You understand where we are.
I do.
You understand where you are completely, right?
Yes.
So I want you to tell us in an informed way, can we go ahead or not?
Member Jacob, as I said at the outset, you please do feel free to proceed. I never raised an issue with the panel proceeding with any questions, and I just want to have it on record that I did not raise an issue.
Okay.
In
so
addition,
I'm sorry, then let me place on record that I'm so sorry. I sometimes have problems with the English language because I spoke Gujarati when I was a kid, and sometimes this has an impact on things, so I apologize on my side too.
Okay. That being the case, we've both apologized. I can give you the answer to the question that you asked me to obtain. I've received the instructions.
Ah, yes?
Yes. The answer is that the Tribunal Committee approached Mr. Sooklal in order to give the evidence that he's given today.
Okay, and was he informed that his decision was voluntary, that he was not compelled at all?
He was.
Okay. Thank you very much.
I think that I understand, in as far as I'm going to be able to today, the level of protection that I can afford Mr. Sooklal. I will raise the objections that seem to me to be pertinent, and you will decide on whether they have merit.
And we will deal with them, and we will deal with them as fairly as we possibly can.
Yes.
That doesn't mean that the objection will necessarily be decided in your favor.
Of course, of course. And my suggestion was only raised in order to expedite proceedings, so that we don't ask the same question
we understand
again.
each other completely.
Excellent. Thank you, Member Jacob. Now, before we proceed with the evidence again, I have been asked by Mr. Sooklal for 5 minutes, please, to confer with him once again. And I know that I'm asking for a huge number of indulgences, but if that is possible, it would be appreciated.
Of course it's possible. It's fundamentally unfair for us not to do that. Already you're working under very serious constraints, and we'd be the last to make them worse for you. So you have your 5 minutes.
Thank you.
Another few minutes. Yes. I think we should have our own conversation.
Okay, let's go, let's go. Are we ready?
I believe so, Member Jacob.
It was not.
Should we proceed? Okay. Member Jacob, the witness is no longer sitting in the chair. He has elected to withdraw, and we have elected to withdraw him as a witness. With thanks.
That is his right, and sorry.
Beg your pardon, Member Jacob. I am just conferring with my colleagues. He has, and I misspoke, we are not withdrawing him as a witness insofar as what he's already attested to should be disregarded. We don't suggest that that is the case. That is, of course, a question for you to decide. I merely meant to indicate that his testimony is now at an end.
Okay, and of course you're right. You have the right to argue. Obviously, you have the right to argue, if you wish to, that the evidence is entirely credible and has to be accepted in its absolute entirety. You are entitled to do that, and you must understand that, and you will not be stopped in doing that. Right, where do you want to go to now?
So, you'll recall, Member Yaqub, that we interrupted Mr. Holden in the giving of his evidence in order to accommodate Witness X. You've heard from Witness X the facts and circumstances that fall within his own personal knowledge and his intimate personal knowledge of the goings-on and as far as corruption is concerned. Mr. Holden will add to that the objective facts that demonstrate the corruption that this session is about. The evidence that he leads is entirely independent from Mr. Sooklal's evidence and will be the pillar of an argument for corruption. But to the extent that Mr. Sooklal's submissions are accepted, to the extent that his evidence is found credible, that will add flesh to the bones, so to speak.
We have half an hour, right?
Yes, that's correct. Beg your pardon? Just need a few moments. Thank you, Mr. Holden. So, during your evidence, there were two highlights that we covered. Highlight one was Joe Modise and Conlog, and highlight two was BAE Systems and the agent system. Highlight three, and this is interestingly dovetails with Mr. Sooklal's evidence, concerns the Chippy Shake memos. I would like for you to give evidence on that, if you will, but before you do so, may I ask if you have been here for the majority or all of Mr. Sooklal's evidence?
I have indeed.
Perhaps it's best then, seeing as it's fresh in the memory at the moment, if you can give us your comment insofar as you are aware, and I understand that you have no personal knowledge of the nature that Sooklal has, insofar as you are aware from the objective evidence, can you give us your comment on the evidence to which Mr. Sooklal attested today?
I'd be happy to. Of course, it's up to the panel to make their own judgment. I think the first thing that I'll say is that there were matters that were attested to in Mr. Sooklal's proceedings that I believe that we have corroborating evidence of. I would like to lead some of that corroborating evidence, which I'll do as we go through some of these highlights. That's the first thing. The second thing is that in my experience as an investigator, focusing on the arms trade for the better part of 13 years now, I've had the opportunity to deal with a number of whistleblowers, and in that process, I've become very familiar with the situation where people who have absolutely vital information about corruption may also be involved in that corruption, or at least party to the proceedings, or somehow or other morally tainted by being in their proximity to those proceedings. That is a challenge that we have to deal with as investigators, and our challenge in so doing is to try and establish what the objective facts are based on what they present, and separate that out from whatever conflict of interest they may have or acts they may have to grind in the proceedings. to my mind, based on 13 years of investigating the arms deal, there are certain aspects to Mr. Sooklal's evidence that do stand to be further investigated, that could be profitably mined for further evidence. I can't say with 100% certainty, but it's also not my job to do so, that everything he says is absolutely correct. I hope that makes that clear.
Yes, thank you very much. If I've understood you correctly, what you say is that there is objective evidence to corroborate aspects of his testimony and that you will traverse those during this session.
That's correct.
Thank you. So, on to highlight 3, the Chippy Shake memos. Let's turn to them if we can. First, can you explain what role Chippy Shake played in the arms deal?
Certainly. So Chippy Shake, as you will no doubt know, was the brother to both Mo Sheikh and Shabir Sheikh. Has been mentioned in previous sessions, Shabir Sheikh, and I think the panel members have already indicated knowledge of the Jacob Zuma litigation, the Shabir Sheikh litigation. Shabir Sheikh was a party to the arms deal as a contractor, but Chippy Sheikh was absolutely central to the transaction. I would argue that he was omnipresent. As Director of Acquisitions in the arms deal, he was present at virtually every level of the decision-making process. I point to a couple of very key bodies, well, the one key body, which is called SOFCOM, which is the Strategic Offers Committee. To get a little bit technical, what that committee did was when bidders submitted offers to be assessed, those bids were then sent to various subcommittees to be evaluated. There was a finance subcommittee, an offset subcommittee, and a technical subcommittee. All of those results were then collated within the series of the SOFCOM committee, which then forwarded information up the chain. In reality, and I think that's attested to by a huge amount of evidence presented both in the Shabir Sheikh trial and elsewhere, the information that SOFCOM presented was effectively not able to be challenged by those above it because they hadn't had access to the primary material. In that role was a very complicated, and I'd argue a legally questionable body. That body was entitled to give rulings on what could and what couldn't. I would argue wasn't entitled to give rulings on what could and couldn't proceed or how matters should be judged, but in the end it did so. So I think he was absolutely central to the entire acquisition process.
Thank you. Was the evidence that in this role Chippy Sheikh was a party to selection irregularities?
I think there's so much evidence that I don't quite know where to begin, to be honest. He is involved, he's implicated in irregularities in the majority of the contracts. I'm going to focus on one right now, just as an example, which is the German, the Corvette transaction, which was awarded to the German Frigate Consortium. Was we're hearing evidence that was a transaction that involved not just the German Frigate Consortium, but also Thales as a subcontractor to provide the combat suite. In that role, there are a number of decisions that were made exclusively by Chippy Sheikh or by Chippy Sheikh in combination with a man by the name of Lou Swan, who was the chief of Arms Corps, and who I'll just very briefly mention there were also allegations of corruptions against. One of the best examples was that when the bids were submitted for the German Frigate Consortium, every single one of the bids failed to meet the minimum bidding requirements under procurement law in South Africa. Those bids should have either been rejected in the process, the process should have been started anew, or entirely rejected. Instead, it was decided that all the bidders would be continuing to be considered, and that decision was largely made by the SOFCOM committee. I think probably the most important decision was that the German Frigate Consortium failed to conform to minimum bidding requirements regarding the defense offset program. That should have again disqualified them from proceedings. Instead, Chippy Sheikh and Lou Swan directly ruled that both should proceed and that shouldn't be held against German Frigate Consortium. I should also point out that in that process of arriving at a series of scores that led to a recommendation to Cabinet, that there were a vast number of calculation errors that were made. The combined effect of all of this was that the German Frigate Consortium was not only allowed to bid, but it won the contract. And when the Auditor General's Office was empowered, which was empowered to investigate those transactions, looked into the process, they came to the conclusion that if the irregularities had been resolved and if the calculations had been done correctly, German Free Consortium would not have won the contract. In fact, the contract would have been duly awarded to Bazan, which was a competing bidder.
Thank you. Is there any suspicion that Chippy Sheikh made these decisions for untoward reasons? And what is your evidence in that regard?
Certainly. And this, I think, again, to go back to the evidence we were hearing prior, speaks to, I don't know if the panel recalls that Mr. Sooklal referred to a $3 million payment that was made to Chippy Sheikh. In this regard, I think his allegation is very well founded. If I may return to a document that I've spoken about before, which is called the German Police Report. I'm also going to refer to another document which I attached as Annex CC to my joint submission, which I call the Chippy Sheikh Memorandum. The essence of the German Police Report was to set out, and if I have the indulgence to remind the panel, was to set out the findings of German investigators which were probing ThyssenKrupp and other entities for corruption in the South African arms deal. In their raids, they discovered a range of evidence regarding Mr. Chippy Sheikh. I think probably the most damning was a memorandum that was discovered that had been written by a ThyssenKrupp executive by the name of Christoph Holden. And if I may, I'll read the full memorandum into the record. It says, it's headed South Africa. The last trip, 27 to 30/07/1998, so that's the 27th to the 30th of July 1998, was suggested by C. Sheikh, Director Defense Secretariat. During one of our meetings, he asked for more explicit confirmation that the verbal agreement made with him for payment to be made in case of success to him and a group presented by him amounts to $3 million. I confirmed this to him and offered to formulate this agreement in writing at any time and proposed thereby...
Sorry, can you go just a little bit more slowly when you read it?
Apologies. Where should I resume?
No, you can carry on from here, but just
okay.
go. Yeah.
I'll start from the beginning of the sentence, if I may. I confirmed this to him and offered to formulate this agreement in writing at any time and proposed thereby to put the latter in a safe that can only be accessed jointly. C. Sheikh will report back on this shortly. Mr. Sheikh has stressed that the BVTRT offer, now if I may just intercede there, that was essentially the German Free Consortium he was referring to there. Those are acronyms for the member parties of the German Free Consortium. Mr. Sheikh stressed that the BV/TRT offer was pushed into first place in spite of the Spanish offer, which was 20% cheaper. The Spanish offset, only DTI share without social components, was according to him also valued higher than ours. In this respect, it had been no simple exercise to get us into first place, according to him. Mr. Muller/B+V was informed by me at that time about the arrangement made and also about the conversation I just had with C. Sheikh, whereby he asked to reserve the aforesaid amount for following prices negotiations, to which he agreed. If I may interpolate there, I think some things that are interesting to be pulled out. The first is the last paragraph, which appears to indicate that the German Free Consortium was at the very least considering accounting for bribe payments, which I would characterize them as, within the contract price of the corvettes. So the South African government would essentially be paying for the bribes paid to its own officials. I'd also point out that what Mr. Sheikh said about how difficult it was to push this bidder into first place is borne out very well by the draft Auditor General's report, which establishes very clearly that he made numerous interventions to ensure that was the case. I should also point out that there was, subsequent to these raids, the discovery of this memorandum, there was a German-Swiss mutual legal assistance request that was filed with the office in Bonn, if I'm not mistaken. And the German-Swiss mutual legal assistance request was very explicit. It said, with the help of the seized records, proof can already be led that the above-mentioned agreements of Thyssen, Rheinstall, Technic GmbH, that's ThyssenKrupp as I've been referring to them, were abided by and the promised funds indeed paid. In this way, the consortium paid through the middleman Ian Pierce, who had signed the commission agreement on behalf of Marion, $3 million to the South African official Sheikh, who acted for arms call, so that he, Sheikh, in violation of his official duty, could promote the conclusion of the agreement for the delivery of the corvettes. If I may just point out, you may remember that Ian Pierce was mentioned yesterday. He was a shareholder in Futuristic Business Solutions, a company in which Joe Medice's close associates hold shares and which received numerous contracts in the arms deal. I should point out, if you would like to read the full story of how that bribe agreement was affected, it is detailed in a lot of detail, both in the joint submission, but also the German police report. To summarize the substance of that, what the German investigators were able to establish was that the agreement was formalized by a contract that was placed in a secret safe in the UK. In the months following the arms deal's conclusion, meetings were held in London to withdraw those contracts, remove any indication those contracts had been placed in the safe, and affect the transaction. And the German investigators were absolutely certain that the entity with which Chippy Sheikh had contracted, which was Marianne Limited, had indeed been paid the $3 million.
Chippy Sheikh was implicated in the submarine contract as well. Can you tell us more about that and the evidence there?
Certainly. So the submarine contract, what I think is important to note, was also subject to a series of irregularities. I'm not going to go into them here because they're dealt with in the joint submission. Suffice to say that, again, when the draft Auditor General examined those contracts and recalculated the scores, the German Submarine Consortium did not emerge as the preferred bidder. What emerged subsequently in a document which we refer to as the Debevoise and Plimpton report, which the commissioners have been given, was that Chippy Sheikh had entered into a series of business arrangements with one of the winning contracting parties to that contract subsequent to the arms deal. By way of background, the Debevoise and Plimpton report was a report by a law firm, Debevoise and Plimpton, who were hired by Ferristal, which was one of the contracting parties in the German Submarine Consortium, and their job was to interview staff of the German Submarine Consortium and assess documentary evidence, and in so doing establish the legal liability of the company in terms of corruption. That document was leaked to the press in 2011 and detailed that the German Submarine Consortium, through Ferristal, had made over 30 million euros of commission payments. Those payments were made to both Tony Georgiadis, who appeared in another contract, and to a company controlled by a man called Tony Ellingford, who later emerged was the executor of Joe Medice's estate once Joe Medice was deceased. I point out that the Debevoise and Plimpton report was absolutely central to the allegations of corruption in the arms deal. That was submitted to the Sariti Commission of Inquiry. The Sariti Commission of Inquiry refused to admit it on various grounds, which I believe were spurious. In the end, it decided to address the Debevoise and Plimpton report in the first volume, and what appears from that is that the Sariti Commission placed no weight on the content therein. And in fact, it appears, this is an argument made in the Corruption Watch and R2K papers, that the material mistakes in their way they characterized the Debevoise and Plimpton report suggest they took no care in even bothering to familiarize themselves with the content of the allegations that were made in that report.
Thank you. Chippy Sheikh appeared before the Sariti Commission himself. What did he say about these allegations and what was asked of him?
Thank you. And again, this goes to the issue of whether the Sariti Commission conducted its inquiry correctly, but also the fact that Mr. Sheikh was given an opportunity to respond to all of these allegations I've just outlined. He appeared for, as far as I recall, it was just a single day. The vast majority of his witness statement dealt with a matter unrelated to any of the allegations I've just mentioned, related to the BAE Hawk contract in which he was a part. At the very end of his testimony, the chairperson and Judge Musi, who was also a commissioner, decided to pose a series of questions to him. In the Corruption Watch and R2K process, they submit that the questions were meant to elicit a broad denial and did not attempt in any meaningful way to assess the validity of the allegations. And if I may, I will read from the record of the very limited examination. This was one of the few questions that the chairperson asked of Mr. Chippy Sheikh. He said, lastly, there are various allegations which are leveled against you. Would you think against you, do you think that any of those allegations, which are incorrect in any of those books, and I think the chairperson there was referring to the books that I had personally authored, and we had submitted to the Sawiti Commission for their consideration. Chippy Sheikh responded, "Sir, most of those allegations, I have not read all the books, so I cannot comment on all of the books, but the allegations are untrue." Chairperson then commented, "So the allegations are untrue, thank you." And that was the substance of the examination. I'd like to point out, if I may, that I'm sure Mr. Sheikh was aware of many of the allegations against him because they were published in the media, but I do find it quite striking that he was asked about allegations in books, and he responded that he hadn't read the books, but regardless of not having read the books, he could incontrovertibly say those allegations are incorrect.
Thank you, Mr. Holden. Members of the panel, there is one more highlight. Highlight 4 is the Shabir Sheikh trial in the case against President Zuma that I need to traverse, but there won't be sufficient time within the 8 minutes that remain for me to do so. I don't know whether the panel has any views on how I ought to proceed.
How long will it take?
About 15 minutes.
Go ahead.
Thank you. So you've spoken at length about Chippy Sheikh, but now let's turn to his brother, Shabir Sheikh. He was famously convicted in 2005, which led to charges against Jacob Zuma. To make things clear, can you outline the key players in that trial?
Certainly. I would like to, before I begin doing so, I should like to point out that the Shabir Sheikh case and the Tony Ngeni case were the only two cases where there were convictions that were sought and successfully gained by the National Prosecuting Authority. In that, I think it's a very interesting case to look at to establish whether there is corruption in the deal, which I would argue the case shows incontrovertibly. To return to the question, the entities that were involved were the key players, I would argue, were Shabir Sheikh, who, as I mentioned before, was the brother to Chippy Sheikh, and also to Mo Sheikh, who at various times served in government, and including as the head of state security for a period. In Corby Holdings, which was the central holding company of Shabir Sheikh, Alan Tettard, who we've heard about before, who was an executive of Thompson CSF, and that's another key player. It's Thompson CSF and Thompson CF Pty Limited. Those were the two companies, arms companies, as they were represented in South Africa. And the last entity is African Defence Systems, which had earlier been known as Altec, but subsequently been known as African Defence System from, as far as I recall, at least 1996 onwards. The substance, I'm going ahead, but maybe I'll return to you.
Okay, thank you. Can you explain how Thompson CSF and Sheikh's companies attempted to make money from the deal?
Certainly, it was quite a simple arrangement. The Corvette contract was made up of two contracts. The first contract was what you call the ship platform, and that was what was given to ThyssenKrupp and other contractors. That essentially is just the chassis, the actual ship itself, rather than any of the armaments or any of the electronics that control combat. There's a second contract that was issued for what was called the combat suite, and the combat suite was essentially the brain of the corvettes. It controlled the response and firing systems, but also provided armaments as well. Thompson CSF from a very early stage, and I led some evidence about this before, both Thompson CSF and Shabir Sheikh viewed that contract as a potential avenue in which they could make money by securing that contract. From 1995 onwards, Thompson CSF and Shabir Sheikh had entered into a joint venture partnership. Shabir Sheikh had done so through Corby Holdings. The essence of the conspiracy, if I can call it that, was to use political leverage to ensure that Thompson CSF and African Defence Systems, which was the local contractor which was required, would win that combat suite contract.
Sorry, thank you. In the Shabir Sheikh trial, what was the stated role of Jacob Zuma and Chippy Sheikh?
I think this is quite interesting, and again, I think speaks to the testimony prior. I noted that Mr. Sooklal claimed that a $1 million payment had been made by ThyssenKrupp to Chippy Sheikh. While I can't give evidence that is certainly true, what I can say is that it's incontrovertible now that Chippy Sheikh was meeting directly with executives. We know that he met with Thompson CSF in 1998. According to the state's version of events in the Shibir Sheikh trial, Chippy Sheikh relayed to the parties that if they did not, and I'm paraphrasing here, if they did not contract properly with his partners and friends, he would assist them. If they did not, he would make things very difficult for them. Jacob Zuma enters the picture in a rather circuitous manner. Essentially, to short-circuit the story, at the time when it became apparent that Thompson CSF and African Defence System were likely to win that combat suite, the directors involved in that company were informed by various sources, intelligence sources in particular in France, that the government of South Africa viewed Shibir Sheikh askance. They didn't particularly like him as a potential contractor, and that could present a problem. As such, when African Defence Systems was bought by Thompson CSF, the companies were structured so that Corby Holdings, which was Shibir Sheikh's company, were excluded from the shareholding, which effectively meant that Shibir Sheikh would not make any money from that transaction. As a result, Jacob Zuma met directly with various members of Thompson CSF to impress upon them the political suitability of Shibir Sheikh as a partner, and to allay their fears, which were apparently their impression that Shibir Sheikh wouldn't qualify as a BEE compliant contractor. I should pause to note that, interestingly, the way that issue was resolved about being worried about being BEE compliant was it, and this political problem was that Corby Holdings was given a share in African Defence Systems effectively, but a BEE share was then granted of 20% to Futuristic Business Solutions, who I don't need to speak about again, I do not think. I should also mention that I think it's very, very well known that on the 30th of September 1999 in Durban, it's recorded in the trial that Sheikh solicited a 500,000 Rand bribe per annum on behalf of Jacob Zuma. On the 11th of March 2000, Zuma met with Sheikh in Tettard, and he confirmed that 500,000 Rand bribe. The bribe was to achieve two objectives. The first was to protect Thompson CSF from any investigations into the arms deal. The second of which was to promote the company's interests in the country on an ongoing basis. I should point out that by September 1999, when this bribery contract was being discussed, allegations had been placed before Parliament by Patricia de Lille of wrongdoing in the arms deal. In total, the state alleges, Shibir Sheikh didn't just solicit the 500,000 Rand bribe for Jacob Zuma, but he was also involved in making payments directly to Jacob Zuma. And in the first trial, the first Shibir Sheikh trial, they were able to total 238 payments paid by Sheikh and his various companies to Zuma with a total value of 1.3 million Rand.
Thanks. Can you briefly summarize for us what Judge Squires found in the case?
Absolutely. So I think briefly, the Judge Squires found almost entirely in favor of the state's case. Mr. Shibir Sheikh was convicted on all three counts. To go back to those counts, one of the counts was a count of fraud for the way in which he represented payments to to Jacob Zuma in his books. The two other counts were corruption related. The first was that there was what was then later called by the SCA a generally corrupt relationship between Shibir Sheikh and Jacob Zuma, in which Shibir Sheikh paid Jacob Zuma monies over a period of time, in return for which Jacob Zuma would perform services to support Shibir Sheikh's businesses. And I'll quote from the Squires case here. He says, "The case on this count is not just convincing in total, it is really overwhelming." Because the extent of the evidence that was led to prove this, I think I would agree, was properly overwhelming. On the count of soliciting the bribe, Shibir Sheikh was again found guilty, and the arguments put forward by Sheikh that he was merely soliciting a donation for the Jacob Zuma Education Trust was rejected.
We all know now that the NPA attempted to prosecute Jacob Zuma for the case. Can you briefly outline the history of the prosecution?
Certainly. So, clearly, Shabir Sheikh's indictment in 2005 created a situation where I would argue the NPA was obliged to prosecute Jacob Zuma and Tint, which they did shortly thereafter. They made the first indictment in 2005. Shortly thereafter, they were struck from the roll by Judge Herbert Msimang because the case was not ready for presentation. However, he was re-indicted in 2007 under substantially larger, more enlarged charges, which I'll deal with shortly. That then is struck by Judge Nicholson in September 2008 on the basis that Nicholson found that there was a political conspiracy underpinning the prosecution. That was then reinstated by the Supreme Court of Appeal, which found that Nicholson had erred in his reasoning. And then finally, drawing a line under it, we thought, up until recently, the matter was withdrawn by Mokotedi Mshe, who was then the acting National Director of Public Prosecutions. After the disclosure of the so-called spy tapes, he withdrew the prosecution in 2009, shortly before Jacob Zuma became president. He argued that the spy tapes, as they were called, irredeemably tainted the proceedings. I would clearly disagree with that argument. I'll explain a bit more if I have a bit more time to do so, although I do set that out very fully in the joint submission as well. I would argue that in 2017, I would point out that the Supreme Court has just ruled that the decision of Mokotedi Mshe had to be withdrawn on reasonableness grounds, and the NPA is now to decide on a prosecution afresh. And we await to see whether the NPA has, I hesitate to say the independence, but I would rather say the will to proceed with what I think is a very compelling case.
A compelling case, but there was new information and new charges in Zuma's second indictment. Can you briefly describe this?
Absolutely. So the charge was reformulated as racketeering. The essence of that was that Nkobi Holdings, which is Shabir Sheikh's company, was in effect a corrupt enterprise, and that because of Zuma's role within that enterprise, he was in effect its employee. In addition, based on raids that were undertaken and new evidence that was discovered in the Shabir Sheikh trial, the time of payments that were considered was extended, and this meant that the period of time considered went from the 25th of October 1995 to the 1st of July 2005. The total number of payments that they recorded was 783, and the total value of those payments was just over 4 million rand.
Thank you. We all know that the charges against Zuma were dropped just before he became president. Can you speak to why his case was dropped and whether this was sensible at all?
I think it's very clear based on the record that the decision to withdraw the prosecution was unfounded. I think that was incredibly clear from the Supreme Court of Appeal judgment that set aside the Nicholson judgment. It said a very simple test, actually. It said prosecution is not wrongful merely because it is brought for an improper purpose. It'll only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent, something not alleged by Mr. Zuma, and which in any event can only be determined once criminal proceedings have been concluded. The motive behind the prosecution is irrelevant because, as Shriner J.A. said in connection with arrests, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. I would argue that the test that emerged out of that judgment was whether there was a case of merit that had merit against Jacob Zuma, and I would point to the fact that Mokotedi Mshe, when he withdrew the charges, actually explicitly stated when he was giving his reasons for withdrawing the charges that he was not withdrawing the charges on their merits. On that basis, I have not seen information in the public domain that suggests that the decision to withdraw the charges are irrational, and I can't see any reason at this point why the charges shouldn't be reinstated. I'd like to point out that this is maybe not a legal proceeding, but the question always gets asked, isn't Jacob Zuma innocent until proven guilty. And I think that's true in legal terms. I would argue that the Shibir Sheikh trial is so damning and the evidence is so utterly overwhelming that that requirement falls away.
Thank you. In that case, I have no further questions for this witness. Thank you, Mr. Holden.
Thank you.
Well, that was 13 minutes. Congratulations.
Thank you, Member Yacob.
All right. Been a long day. Thank you, everybody. Have a good night's rest. And, we'll see you tomorrow morning.
Thank you, Member Yacob. If I might just ask one question for Mr. Holden's benefit. I assume that the questions that one would ordinarily ask at the end of a session will be directed to Mr.
Sorry, you're being interrupted by some cell phone noise or something.
Yes, sorry. I just wanted to inquire about what the panel had in mind in regard to questioning Mr. Holden on both his evidence earlier this morning and more recently now. Will that take place tomorrow, first thing, or will it take place at all? Or?
Okay, I think in a sense it's you who must decide and how you want to go and where you want to take the case, and we leave it in your hands.
Thank you.
All we want to know is you be ready to proceed at 9:15 tomorrow morning, huh?
Yes, of course I will. I don't know whether I was clear initially, but all I was inquiring was whether the panel members have any questions for Mr. Holden, and if so, should we do them now or should we do them tomorrow morning, for example?
I think do them tomorrow morning, and we're quite happy to wait until tomorrow morning to discover the menu.
Thank you, Member Yacob. Understood.